when you heard,
So no one I'll put out. As usual. Okay.
Hold on. Good morning, everybody. Good morning. Good morning. Good morning. Good morning. Put a 1 in the chat if you can hear me. Put a 1 in the chat. First and foremost, shout out to all the people joining in this morning. The judge is not on the bench. But we got right now is we have a special guest at 11 a.m. and we have a exclusive that we're about to share. I want to make sure you guys are in there. Put a 1 in the chat if you can hear the sound of my voice. I don't know if you guys can hear me. I don't know if you can hear me. Okay, good morning, P. Cantan. MNPD, finest, good morning, good morning. Leak you, Nicole, what it do, what it do? Toya B is the first one, you win the prize. Ah, yeah, you going to Hawaii. You going to Hawaii. All right, everyone, good morning. Everybody, good morning on Twitter. Good morning on YouTube. Good morning. Thank you for checking in. We got something special at 11 a.m., but we have something special now as well. I'm live on YouTube. I'm live on at Hip Hop Inquirer, ladies and gentlemen. Good morning. I'm on one. I am on one today. I am on one. Good morning. They tried to give me a timeout. They said, Mr. Byron, we got to give you a timeout. We got to make up something. We got to give you a timeout. You're doing too much. You're writing stories on protesters. You're giving them shine, and you're calling out the things that don't that you shouldn't be talking about. You got to be kind of like playing. You got to be on the side of the court, and you can't be nice. Oh, then you got a picture out there of Young Thug, and no one else got the picture, and you got. I don't know who you know, but you got the picture. But we don't really have any evidence that you was recording. But let's bring both of you up and kind of like bring you both together. So when I say something, it'll appear that I'm really talking to both of you, but I'm really only talking to the other person. But you can just be up here too and kind of look like I'm talking to both of you, and everyone can run with it, and then you memorialize it in writing. But we're going to talk about that memorialization in writing. We're going to definitely talk about that. We're going to talk about that. I'm probably not the guy you probably want to do that with, but we're going to talk about it. We're going to talk about it. We're going to talk about it. We're going to talk about all of it. But we're going to bring in the legal experts. We don't play those games. Ladies and gentlemen, if you've built your name and you built your reputation as someone who follow the rules and don't break the rules and everything, then you have someone that you don't even know that would just make up something. You got to really address this. You got to address it the proper way. You got to address it. So when people say, "I'll just let it go," don't listen to that. If you didn't put that work in all those years, you can't tell someone to let it go. We let it go when it's corrected. We don't play those games. What time is court starting? It starts when it starts. It starts when it starts. They want some other stuff now. It starts when it starts. It starts when it starts. They want to start the court case with a with a little shade like they did yesterday. That's what I see. So we gotta, hey, listen, they say fair exchange is never a swindle. So we gotta, give it back. We gotta give it back. All right, guys, stand by. I want you guys to just watch this. Just watch this for a second.
When you heard the allocution being given by Ms. Hilton, were you a bit concerned about what he had to plead to?
No, because I knew that the facts that she was laying out were not accurate, and it's no different than the state putting things in an indictment. So I wasn't concerned, because if there's anything that all of us have learned in this case, it's that you got to be careful with factual acknowledgments you agree to, right? You better make sure those are factually accurate, or that may come back to cause you trouble later.
Well, we saw what happened with Mr. Sledge. And,
we did,
and
right?
It's how that came back to bite him in the behind.
So here's a man that signed those factual acknowledgments in order to get out of jail.
Guys, can you hold down, please? Please?
There's a man that signed those factual acknowledgments in order to get out of jail and go home, and then it came back and caused him trouble later, and now he's in prison.
Right.
So everyone is going to be, I would expect, super cautious of factual acknowledgments. And given that my client didn't do anything, there's nothing they can say as a factual acknowledgement that is accurate and true that would hurt my client. So I wasn't worried about that.
You were the first attorney who requested for your client to come out because initially it was only Mr. Harvey's client and Ms. Westmoreland's client.
Right.
Obviously one and the same. And it's interesting, you usually the first one, not the first one, but mostly the first one that steps up and brings something to the attention of the court. And I saw that was being played out. I said, is someone going to say anything about the other defendants not being there? And you stepped up.
It was more that I thought he would want to, given all that they had been through together over the past couple of years, I thought he would want to be there to see that process play out, see what he had to say, watch what the state does with the factual acknowledgments, see specifically what he pleads to so he could understand. And I didn't know it for sure, but I was pretty sure he'd want to see that. And when the judge asked him, my client said, yeah, he wanted to see that.
Last question. When you saw myself and my colleague walk up to the podium, I know what you told me off the record, but what went through your mind when you actually saw that play?
I can't say that on the record, too.
You can't say that on the record. No, don't say that on the record.
I had no idea. I had no idea what she was going to say to you, too, because I didn't know there'd been any issue with that yet. And it kind of surprised me a little bit because I think of y'all as professionals, and I would imagine that you'd follow the Rule 22 rules.
Absolutely.
So all I can imagine is with you guys, there must have been some confusion.
In my case, it was very much confusion.
I don't think you would intentionally break any of the rules.
Not 22 years covering even Judge Barnes, so I don't think...
yeah, and the Rule 22s are, the orders are a little bit complicated, so I'm not surprised you can trip up on it. But, y'all have been doing a great job covering the trial, and I expect it to continue no matter, what you have
I said that was the last question, but did you get my email today, early on Monday, the email I sent regarding shielding up the Detective Belknap from the cameras? You were copied on that, and I said our media outlet was against shielding all the witnesses, as you said, but particularly Detective Belknap, because he was one of the key witnesses that testified 10 months ago.
Yeah, and I believe that Belknap has been shown on camera in the past. I may be kind of wrong on that one. But unless the standard the state has to show in order to have a witness not shown, and I can't remember the exact language, but some type of threat, some concern that they can substantiate. So when the state puts up these witnesses and says, we don't want these 4 or 5 to be shown, now it's not required by the court order, but what happens is just the process. This is too long an answer for you, but I got to explain it. That as you know, that process is they highlight the witnesses they don't want shown, and then on Monday morning we can object to it, and then they have to. The thing would flow a lot smoother if they would say, we don't want these witnesses shown and here are the reasons. Then I could make a well-reasoned, rationed
and that's
decision.
usually how it's done.
before Monday on whether I'm going to object or not. Because of the way they do it now, I just object to all of them. And then,
and let them
of course, if the
show their
state
cards,
puts up
right.
a reason, I may withdraw my objection because I'm not.
And you
sure,
did that. You did that
know.
once in the past, recently. As a
Yeah,
matter
I've
of fact.
done it, and so I've asked for that to happen. It hasn't happened. But I will say that before court on Monday morning, Mr. Atkins came up and discussed with me some of the different ones, and I think I withdrew objections on maybe 2 of them, and I think he maybe pulled back on a couple of those, and I don't remember where we are with Belknap because the last 2 days have been 2 weeks.
Shouldn't the media be apprised of those same reasons that they provide? Because ultimately, we have to be able to raise our issues as well.
Yeah, I would think that y'all should be apprised of it as well, because in many ways, you've got as much of, if not more, of a stake in having those witnesses shown than we do.
Absolutely.
Now, we do have a stake. We have a right to a public trial, and I contend that right to a public trial, especially in Georgia, includes the right to have those witnesses shown. But you, as the media, have an absolute right to that, especially in Georgia. So I would think that you
and especially
should
this is the longest trial in Georgia, and especially millions of people are watching it. And now we have 2 less cameras in the courtroom,
Right.
which gives more control to powers that be to regulate how that's happening. And hopefully law and crime will pretty much protest anything that they see that should be covered.
And I'm not going to speak to Whitaker's decision to modify y'all's Rule 22 because I don't know exactly what happened. I don't know anything
Right, no,
about
you can't speak to it.
And I can't speak to it.
Right.
But I think law and crime, I hope, will do a good job. I've asked the media to not just leave me as the only one objecting for not showing. And I missed your email, but I'm glad you did object.
Oh, absolutely.
Because I think it carries more weight when the media objects than we as defendants object.
Well, I can't attest to this, but I think when I sent that, I think I was probably the only one, while my other colleagues were copied on it. But yeah,
I did get your email. I'm sorry.
Right.
Yeah.
I saw it initially. I mean, I'm with Mr. Weinstein because unless you can articulate this to the court, then in their life, if there's a safety issue, then I'm with that.
Yeah.
I've had to shield FBI agents that are undercover.
Right.
So
But if it's an undercover officer, I'm not going to object to that.
Right, absolutely.
That's completely reasonable. But anyway, I'm really glad to see the media objecting as well, because again, I think y'all have a bigger stake in it than we do.
Yeah, and I will say this, and I want this for everyone to know, that I started old school with pen and paper, and I have no problem with no electronic devices. I've covered too many federal cases, so it really don't matter.
I'm looking forward to seeing your sketches.
Absolutely. Oh, my sketches. Ladies and gentlemen, thank you, Mr. Doug Weinstein.
You guys, this is I came over here.
Yes, ladies and gentlemen, that was an interview I conducted yesterday after all the drama that unfolded inside the courtroom with Doug Weinstein. And yes, Johnny, streets already know. Streets know. They know when that car pull up. They're like, yeah, who that guy? Never seen him before. Who he? Who he is. But at least I gotta make the attempt. But yeah, Doug Weinstein has jokes. I know what that is. I know what that's all about. I had posted a reshared sketch coming out of another trial. I guess Doug, I do light sketching. I don't do heavy sketching. But ladies and gentlemen, waiting for our guests to pull up. Stand by. What's going on, ladies and gentlemen? What's going on? What's going on? What's going on? Stand by, ladies and gentlemen. Stand by. Stand by, ladies and gentlemen. All right. Tell me you can hear me. My guess is 8 minutes away. 8 minutes away. 8 minutes away. All right. All right, here we go. That's right. That's Doug Weinstein. That's Doug Weinstein. I had to put on my what's the movie? You guys know the movie, Silence of the Lambs hat. You remember the Silence of the Lamb? You remember that? I had to put this one on. What's going on, people? What's going on? I have something special for you. I'm waiting for her to pull up. She's about to pull up. Thank you for those who are tuning in on YouTube and Twitter. I'm watching the court feed right now. Well, it's actually not a feed. Remember what I told you guys yesterday? They're working on another. They have another plea deal. Yes. This is what I've been told. They have another plea deal. Let's see if this happens. Let's see if they actually have it locked in. So stand by, guys. Wigs and wine, don't do that. Wigs and wine, don't come up here with that. Don't come up here with that wigs and wine. So listen, last night was something else. I had to fire a few shots over the bow this morning. I had to fire a few shots, ladies and gentlemen. I had to. They tried me. Ladies and gentlemen. They tried me. Harper Blue, what's going on? Listen, ladies and gentlemen, if you're on Twitter, you need to come over here to YouTube and join the comment section. You actually can join on Twitter. Just engage on Twitter, but we over here on YouTube too. Come on over here. We need to run those numbers up. Yeah, I appreciate everybody has been reaching out to me. Goodness, shout out to my guy at CNN, my guy. I can't just put him out there, but top dog at CNN reached out to me, like Mr. Byron. But he's gonna be Dennis. What the heck is going on over there in Fulton County? Why are they playing with you? I'm like, I don't know. I don't know why they're playing with me, but I know one thing. I play back. You cannot expect me just not to play back. I play back. It was kind of, strange the way it went down and everything. I know people said, "Hey, Mr. Byron, let it go. Let it go. Let it go." Let what go? What are you talking about? You let it go. You let him go. You let her go. I ain't letting this go. Can't do that. And for those who just tuned in, I this morning I got a call. I received a call from the official that asked me to take the picture. And I'm gonna put everything in perspective. So that person called me and said, "We told the judge that we gave you permission to take the picture." But what the person did say was, she said to me, which I thought, they said to me, which I thought was interesting, that we told the judge, you asked, could you take a picture? Well, it didn't happen like that. You guys actually asked me to take the picture. I didn't know about what this guy was going to wear. Listen, K. Listen, if you want to engage in this conversation, KMB, I'm watching you. You don't come over. You took the picture against the order. Have you ever been in the military? Do you know what general orders are? You know what the general order is? You know what the general order? Do you know, if you haven't been in the military, you understand what I'm talking about? You've been in the military, so you know what your general orders are, right? United States Marine Corps. Oh, you like Slewfoot. Slewfoot was the Marines. So you respect your last general order. That was the general order. Your last general order is the order you follow. That was the last general order. Come on. You know what it is. I ain't playing no games. I'm not playing no games. I ain't just talking now. I ain't just talking. So in any event, No, I didn't break the last general order. Last order. Well, the general. You actually kind of. I mean, if we're gonna split here, I don't know. I broke it. I broke it at the direction of the commander in chief, Air Force. Okay, and you broke it. There you go. There you go. Actually, based on that conversation this morning, I didn't break it because, well, I didn't break it. I didn't break it. If I was asked to do it, I didn't want. Yeah, they asked me to do it. I'm like, hey, it must be cool. You got it clear. You know, I'm gonna tell you one thing. They have the rules. They have and then they have people who. And they gave me an example of how they claimed that they didn't really understand what it is. This is a general rule order, and you decided to follow the sergeant instead and make it make sense. You know, KMB, I'm gonna be honest with you. I can't fight you there. I can't. Why I can't fight you there? But I can't fight you because apparently it wasn't about the photo. That's the key. It was not about the photo. I'm told today, well, they had time to clean it up. It wasn't about the photo. And what I was also told, and this is exclusive, what I was also told was they didn't have any videos that I shot while the judge was off the bench. However, they did the other person. So why did you call me up there in the first place? And we're going to talk about how bad this got. If you don't have any videos of me doing that, then why am I up here? That's a bigger question. KMB, you and I are going to talk. We're going to talk. We are going to talk, KMB. But thank you, Melanie Snett. That's it. And that's why we're here. That's why we're here. Photos are not recordings. Photos are not recordings. The photos show the possibility. Now, see, now, no. The photos show the possibility of recording. Now you're not making sense. Because if you have a recording, you don't need the possibility of recording. Think about what you just said. The photos shows the possibility of recording. How about show the recording, not a photo? Because the issue is a recording. Think about what you said. I was about to give you some credit there. You don't have to show a possibility when you can show the reality. Oh, okay. So I got people also Twitter. I'm seeing the comments on Twitter. So KMB writes Parley writes. I'm reading what he's saying on Twitter. Can you take stills from video? You're still not making any sense. If we're talking about video, we're not talking about taking stills from video because the comment says you can freeze a frame and do a capture. We're talking about video. We're talking about recording. That's the constant movement of imaging. So you're reaching right now, and I might not give you too much more time. You're reaching now. If you said, Mr. Byron, there's a distinction between photos and video, then I say, okay, you're talking about something. You're not making the distinction. You're not making the distinction. What the judge said, recordings. He didn't say stills. He said recordings while she wasn't on the bench. On the bench. That's important. She said there were videos taken while she wasn't on the bench. That's the key. They have evidence of the other individual taking videos while she wasn't on the bench. They have none for me. Okay, so you're trying hard. Listen, ladies and gentlemen, I'm surprised you guys can't see this Twitter. Well, you can see it on Twitter, but I'm having this small debate with this individual who's trying to drive a point home, but you're missing it because we're going to break that down shortly. I'm gonna let you stay there because we have a guest coming up. We have a guest coming up who has more experience in law than you and I both put together. We having that person come up. Nothing going on in the trial. I'm watching the live to see whether or not it pops up on the screen. To bring it to I'm gonna bring it. No, listen, guys. I'll be around at some point, but I have a few things I'm taking care of. But don't listen, KMB, don't go nowhere. When I drop that link, I want you to speak what you believe when I drop that link. I'm just waiting for my guest to pull up, and we got to show you guys some things. I can't tell you yet. I tell you who the special guest, and they and you know I gotta keep it. Come on, guys, I gotta hold that back. Yeah, don't go nowhere. You better not go nowhere either. KMB, you better not go nowhere. Okay, that's on Twitter. On Twitter. Guys, let me check with my guests to see where they're at. Stand by. All right, guys, I'm back. That was quick. I was about to send this email out. They said you got to send it to my email. You got to send it to my email. I'm like, nah. I got you. All right, ladies and gentlemen. The court is not up yet, but when it does, we'll go to the courtroom. Right now, I have someone that I highly respect in law, someone that understands paperwork, someone that's file motions, argue motions at the state level and at the federal level. She needs no introduction, but I'm going to introduce her. She's a all-star in the legal community. She's a college professor, and she has something that a lot of people don't have: common sense. Without any further ado, ladies and gentlemen, I want to bring up the incredible Professor Akeisha Al-Shabaz. What it do?
What's good, Janice? Thank you for the introduction. I am actually a law school professor. How about that?
Yeah, yes, you are. You are the law professor.
Right.
You don't be playing with the people. You ain't out here doing that crazy.
Not at all.
You've known me for a while, and you know I be on my business. I don't play those games.
Yes. And I'm here to ask the questions that the people want the answers to, Dennis. Absolutely. What the hell happened? So everyone was watching the updates on the YSL trial, waiting to find out who took a plea, who didn't take a plea. When the judge took the bench and called you and Miss Sylvia up and began to reprimand you all for purportedly recording in violation of your Rule 22. What say you?
I am innocent. I've been falsely accused, and I've been defamed.
Oh, the shame of it. The shame of it. Yes. So after our conversations and looking through the internet, a lot of people believe that this reprimand was a result of the photograph you took of Thug with the "I Love Mariah" shirt on. Right. Is that true? Can we debunk this?
Oh, we can definitely debunk it.
Okay.
And I can tell you that I received a phone call from the court official, from the security that gave me the permission to take the photo. They said to me this morning that we talked to the judge, Judge Laura, not the Laura, excuse me, the staff attorney, Lara
Percival,
right. And told her that we gave him the permission to take that picture.
Okay. So this is likely not a result of that photograph.
Absolutely. She said recording.
Right.
It's a distinction between a still photo and a recording.
Now, she reduced this order to a writing, did she not?
She absolutely did. And
would you be so kind? Would you be so kind to share it with the people?
Ladies and gentlemen.
Share it with the people.
Yes, the people have to see this, and I want you to break this down for the people.
Let it be broke. What's up, family? I ain't say hi to the folks. What's up, Susie? What's up, Barcelona? Galatians? Wigs and Wine? What's up, baby? What's up, Fee? Kish? I love saying my own name. So here's the order.
Yes.
Here's the order. All right, let's get into it. I needed to bring glasses. You gonna read it, Dennis?
No, I'm gonna let you read it. I want you to.
Okay. God, you didn't tell me I was gonna be reading. I would have brought. I got 2 pairs of it.
Well, let me read it then.
No, I'll read it.
Okay.
The court, having received information and confirmed recording of proceedings in the above style trial in violation of Uniform Superior Court Rule 22 by Dennis Byron / Hip Hop Inquirer magazine, specifically a violation of Rule 22J, I think that's 1, which prohibits the use of recording devices while the judge is outside the courtroom. In addition to other issues, somebody didn't proofread this shit.
Yes.
I can't stand typos. I fucking swear.
I'm coming from an order.
Come on, this is an official court document. Y'all could have proofread, which prohibits the use of recording devices while the judge is outside the courtroom. In addition to other issues with Dennis Byron Hip Hop Inquirer magazine connected to recording in the courtroom. So that is levying an allegation that there has been past conduct which has violated this Rule 22J1. What say you before we go further? Has there been past conduct? Have you ever been put on notice by this court or any other court that you have been in violation of the Rule 22?
Absolutely not. Absolutely not. And if that had happened, in particular this court, well, no other court has ever happened, but in particular this court, why wouldn't that be in writing, said in court, or told to me? Why would I be the last person to know about this? It's never happened.
So you've never had a warning. You've never had any infraction whatsoever that you could recall that might fit the definition of a violation of Rule 22.
None.
So this is, in other words, some old bullshit.
Some bullshit.
some straight bullshit. All right, let's go further. It is hereby ordered. So that is the factual portion of the order. The rest is the actual order. It is hereby ordered that from the date of this order and continuing from the duration of the trial in the above style case, that Dennis Byron Hip Hop Inquirer magazine is no longer permitted to bring electronic devices into the courtroom and is prohibited from recording in any manner in the courtroom. Dennis Byron Hip Hop Inquirer magazine is permitted to be present in the courtroom, but only without electronic devices. Now, before I go any further, let's finish it and then let's talk about how this impacts your work. Absolutely. Dennis Byron Hip Hop Inquirer magazine is permitted access to the media room. No, I want to break this up because the media room is separate, and I want you to explain to people what the media room is. So let's just stop at this paragraph and tell me if the court stands by this order and it prohibits your ability to record or just to bring in electronic devices to assist you in doing your job as a journalist and not a YouTuber. How would that impact your ability to do your job?
Well, for those who know my work, I use a camera and I use a laptop and or phone to live tweet, which I've done throughout this trial, and also to take notes and to and to keep a record, visual as well as audio record of the proceedings. So that would greatly impact my coverage in this trial. In addition, you put me in the you asked me to do recording in the media room. What am I recording? Walls?
Yeah, that's the next portion. So for those of us who are not familiar with the media room, so this says Dennis Byron Hip Hop Inquirer magazine is permitted access to the media room and is permitted electronic recording devices and may record only from the media room. Any recording from the media room must comply with all provisions of Rule 22. Further violations may result in complete revocation of recording privileges. So explain to us what is the media room? How is it set up? And what type of recording could you do from the media room?
A recording? I mean, we're in a private room. We're in the room. We can talk on our phones. We can, record. I can do interviews in the room.
Do you have access to the live trial? Can you record anything from the media room of the live trial?
Yeah, if I put in a stream box in the media room, then I can capture the stream if I'm in the media room. Well, how about this? I don't need to be in the media room. I could be right in this room right here.
You could be home doing that, right?
The same thing. So this effectively is a revocation of my privileges. It's not they're making a concession. Mm-hmm. Well, I can come in the courtroom. The courtroom is a public courtroom, so I can see the courtroom. Right. So what are you really telling me?
Right.
This is like word salad, and you let it all twist it up.
We'll let you come back in like the rest of everyone else, which is the whole purpose of the Rule 22 is so that you as a journalist would be set apart from your everyday layperson. No.
Absolutely.
Okay.
Absolutely.
Because I just want to make sure that's clear for people, because some people think what's wrong with you doing what we do? Well, let's say this. I get some privileges too, but
quote unquote regular person is there watching the trial. Me as the reporter in the courtroom is not only watching the trial but communicating what's happening to millions of people.
Right. That's so you're allowed to have your phone out. You're allowed to have your laptop out, whereas someone from the public would not be allowed to do those things.
Absolutely, because they take the public's phones when they go in. So you're giving me permission to do something that I would be entitled to do anyway. So that's not.
But we want to understand the breadth of this order, right? So it's allowing you to be there, but it's not even allowing you to be there with your phone. Is that my understanding? Because that's what it seems like. No, you can't bring any electronic devices in. Right. That would include your telephone and or laptop. No,
absolutely. And but before we even go into what I can't do, let's talk about what was alleged they have done. You've claimed that there's recordings, but you haven't produced anything. Where's the proof that I did anything? Why didn't this even be the first thing you asked? Why don't you ask that you do this? Here's some proof this happened on this date. Give me something that. How do you appeal something like this when it's
vague? It's vague. It's vague and it's ambiguous. And there's no specificity as to the allegations you're saying, right? There's no way for you to be on notice as to the exact nature of what they claim you violated. Exactly when did it happen? How did it happen? Who witnessed it? And what evidence do you have of the thing?
The who, what, when, where, why, and how. And that's what I need. When you tell me that, this appears to be intentional, and it appears that it was done to exclude a member of the press for no other reason, especially in light of the fact that the superior that told me, what she said earlier today, she said that we have nothing, we have no proof, we have no evidence that you've done that when the judge is off the bench. If the superiors in the court is telling me this, then what is the judge talking about?
Now, when Brian Steele got locked up, you saw the defense bar come down and rally around that man. Have you heard from other journalists? Are they ready to rally around you in the name of the First Amendment and the right of free press?
The phone calls that I got right afterwards, first of all, they're confused. They want to know what this judge is, what is this judge on? What happened? Then they want to know what's the backstory. Have I been sanctioned for recording or anything like that in the past? I said, absolutely not. Absolutely not. No judge in that courthouse in over 20 plus years. That's never happened.
I don't want to minimize the impact of this because you work in that building.
Absolutely.
And to be labeled a Rule 22 rule breaker,
the rule breaker,
the rule breaker would bring, you know, I think a great deal of suspicion of judges as you walk into their courtroom. They're like, oh, there he is. Right?
Is he recording us?
Right.
Is he doing? Is he breaking the Rule 22? I'm like,
so
no.
Fonnie wants the odor of mendacity to follow you.
Absolutely.
No,
and well, hold on. And I can only this is speculation. I did tweet out a photo of the judge and Fonnie Willis. It was a photo that was online.
Right.
And I've also shot, and I also took a photo of the Sergeant Ingram, and every time he looks at me, he gives me that screw face look, and I had to say, sir, you look at me, and I said to him, I said, I know you were. I said to him yesterday, I said, I know you're responsible for this. He said, no, I'm not.
And all the pictures that you're talking about right now, you took in they were not taken in violation of any rules.
Absolutely not.
Just to make sure, because you know how people are. You know.
Oh no! Every picture I took in that courtroom, it was in accordance with the Rule 22. Even the picture of Sergeant Ingram, hey Sergeant, and the picture of the judge, Judge Whitaker, and all others in that courtroom. So, but you're saying recordings,
right? Multiple. Past and present.
Right. So she intentionally said that. And now think about this. This is a judge knowing that there were a lot of people waiting for the start of this proceeding yesterday.
Right.
She knew that. She knew what was happening online. She saw it had 60, 70,000 people watching. She knew it was the impact of what she did on that bench, and it was intentional.
Right. So the next question people will say is, then why didn't you respond when she brought you up?
It's hard to respond to a close-in statement and she making the ruling. So my position is that let me regroup and let me consult with legal minds to have a better approach in dealing with this and not have a knee-jerk reaction, because people say, you should have said something like the other person. No.
And so now that you've had an opportunity to respond and reflect and consult with legal minds, what is your next step? What is your recourse? What is your plan of attack? What is your get back, Dennis?
The get back is, we had the letter. We had the first letter shot out this morning.
Okay.
The first letter went out this morning. I think I gave you the opportunity to read what was said.
Yes.
And I think that was pretty effective for the first shot over the bow. What do you think?
Right. I think it was effective. And basically, if you don't mind me sharing, the gist of it was that the judge was wrong in her assessment. Her information was incorrect, inaccurate, and that you basically are entitled to a hearing before some sort of due process before the judge could make these findings. So did I sum that up?
You summed it up very well. Okay. And I liken myself, like you said, to Brian Still, how he, like, who told you? No matter who told me, did you do it?
Right.
Like, show me the proof.
Right.
Show me the proof. Right. If there's communication, if there's some type of ex parte communication that you had with others, show them, produce them.
Right.
Bring the proof. Don't just
let me be confronted with the witnesses against me.
And this is a RICO case where defendants are fighting for their life. And if this is how you deal with a non-party in the case, how you deal with the parties in the case?
Well, we see how she's dealing with the parties.
We know this, but I just want to echo that. I'm looking at it. I'm looking at the judge a little like sideways, Judge. You came across to be fair, but this right here, it's like, no. And then she says, confirmed. She said, and we confirmed. How did you confirm?
Right.
When she said,
court having received information and confirmed the recording of proceedings.
Right.
Really?
But when she said that, ladies and gentlemen, it was someone else to my right that I can just say this, the superior said that, we confirmed that she has videos. We have none of you. She said this to me this morning. We confirmed that she has videos out there. There was recording.
So my question is this, right? They got Sylvia. I wonder if she has the exact same order, word for word, verbatim.
I mean, this could be a boilerplate for both of us. I mean,
except for the names being changed. right? Except for the names being changed. Is this is this the exact same allegation? Because if that's the case, maybe she's conflating, right? Maybe she's confused, or maybe she's using this as an excuse to get you out of the courtroom.
I think the latter, man.
Right. I'm giving every possible, benefit of the doubt.
Well, who would? Let me ask you a question. Well, this and you made a good point earlier. I limited it to the officers in the courtroom, but who would be the other individuals that could have said this was happening?
Prosecutors.
The
prosecutors.
Right.
You know they're not too pleased about your presence.
Right. No, they're not. They're not.
They don't.
It started out, ladies and gentlemen. Ms. Love was speaking. Good morning. How you doing? When the first trial started November 27th. As we hear today, she doesn't even give me one of those. Like, what?
Don't even get the head nod.
Ms. Hilton, she gets, but she doesn't even do that. So, and I get it. She's getting pressure from all over. If she can if she could touch the commenters and the YouTubers who are reporting this all over the United States and around the world, she would love to touch him. But I'm sure
she would.
She
could touch you.
She could touch me. Yeah.
Consider yourself touched.
Yes.
How you feel?
Well, it's a first, ladies and gentlemen. This is a first.
It's a first.
And this was intentional. What she said on the bench was intentional, and what she put in writing was intentional. She made it. She emphasized my brand as well as myself, and I think it was a personal attack. And unless you can show me, because we're going to appeal this, obviously.
All right.
Appeal this. If not for nothing, nothing for nothing. If I don't come back in there ever, this still has to be straightened.
It has to be straightened. You have a reputation, right? There's life after the YSL trial. There are other trials.
And the difference between her and I was doing media before she was a judge. I was doing media probably before she was a lawyer. So when you take a shot, I don't know how old she is, but you take a shot at me like this is a personal attack. This is a personal attack. And
Gandhi said Sylvia has the same order. Yeah. So the received information is not even individualized. The allegations, right? They're not. It's a catch-all. They're not particularized. They're not individualized.
It's not individualized and it's not particularized. Actually, absolutely. And this is a catch-all. Let me catch these two. Bring the two. I have to go there, ladies and gentlemen. Bring the two black people. The only two black people recording besides Maurice, law and crime.
Are you two the only two black journalists there? Or you're the only two journalists, period?
Well, hold on.
I don't know. I'm asking. The people want to know.
I had to pause for a second. He said two journalists. One journalist on YouTube.
Okay, sorry. I'm not trying to disparage anyone. I am not. Not going to be Megan Cuniff today.
Oh my goodness. Independent journalists, yes.
Okay, there you go. Thank you, Monica Mo Justice. Appreciate you.
Monica Mo. Independent journalist. It was love. She knows who you are. Of course, she knows.
Yeah, she definitely.
I got a picture of her boss all in Time magazine.
Yeah,
her boss. I got a picture of her boss in Time magazine sitting like this.
Yeah, you're probably not on anybody's Christmas list. You're not even on a Secret Santa. You're not. You ain't even.
So I want people to understand it. When I get these many calls, if I had no less than 20 calls yesterday after this happened. And I got your text while I was in the court. And I'm looking at it, she's spanking me already. I'm still sitting there. I'm like, what the hell?
I'm gonna tell you in real time. I literally turned on the YSL trial just as the judge took the bench, and I was like, oh, my timing is impeccable. And I sat
a lot of people's time was impeccable.
2 minutes in, and she was like, Dennis Byron. I was like, oh shit.
What the? I was shocked. I'm like, wait a minute. Am I being
I grabbed my phone. I was like, I could not believe it. I was like, what? And of course, because the way she framed it, right, that it had been confirmed, I was like, what the fuck did Dennis do?
Right. That's what everyone wanted. What did I do? Like,
Yeah.
I'm like, what did I do?
Right. And you didn't respond. She didn't give you an opportunity to respond. And I understand that in the moment, right? The magnitude of the moment where you have these defendants who are waiting to take a plea.
Absolutely.
Which is going to impact not only them, but their families who are also sitting in the courtroom.
Absolutely.
And the hundreds of thousands or not millions of people waiting on various streams for this to go down.
Yes.
I understand that there may have been some pressure for you to be like, let me get the fuck up out the way.
Absolutely.
Let these people go ahead and do the business of the court. And I can deal with this later.
I didn't want to, while she made it about me in the beginning, I didn't want to echo that because first of all, I wasn't giving her no sound bites. I wasn't giving sound bites. I let the lawyers take care of that. I don't want to give you sound bites. I know you had your sound bite. You feel you got that off. I get it, but it's my time. You can control the phone.
You know the keyboard warriors are, well, if it was me, it's always the if it was me police, but you never know how you're going to respond in the moment.
Right.
When something happens that takes you aback, sometimes that forces you into silence. Right.
Absolutely.
And sometimes it's better for you to sit and properly evaluate so you can respond than to react.
Absolutely.
Right. So your response now will be measured, right? And of course, because that was my next question. How much time before you go to maybe the chief judge of this court?
Well, the chief judge is landing, so
God, never mind. Well, he might want some get back. He have to. Right.
Rest in peace, Kanye. Why do you say rest in peace, Kanye?
We've come full circle. Come on, stop it, Brian Martin.
What is he talking about?
Attack on true journalists. I don't know, but block him because I don't feel like don't do this with me right now.
Right. But what is that? Okay.
What?
Hold on a second. Let me see something. Let me just check something.
Oh God.
Let me see. If he just trolling, if you trolling, man, we gonna.
He trolling. If he trolling, block his ass.
You don't play like that. Now.
This is not cool. That's not cool, Brian. Explain yourself. You got some explaining to do.
Yeah, we gonna see what you're talking about.
Why is she making this false claim in question? I think finally, and Judge Page has an insider snitch.
A snitch is something you got to have something to snitch on.
Yeah.
Hold on a second.
Oh, Ganja says she showed it. The names just changed, and that's again with the same typo too. With the same typo, the other.
Absolutely.
Where is it in the typo? The fourth line of this order.
It was grammatical.
To other issues. How many others you need in one sentence?
Right. It was just grammatically incorrect. Okay, so Brian, you gotta get put on timeout, man. You can't be doing that. Don't be hitting no RIP when you got a reporter and a lawyer on the line. Don't do that. I'm gonna put you on a timeout. You come back when you behave yourself. All right. Go ahead, Ike.
Yeah, that's not cool.
Right. So both got the same document, just the names have been changed. Okay. So yeah, we'll deal with it. But those who know my work know I don't. It's no need for me. First of all, it's no need for me.
Rumors of Kanye's death are false.
Oh, so others are saying that?
Yeah, there's some rumors going around, apparently. But this is not new. So there's been rumors. I guess they just keep coming up. 2 days ago, there were rumors that Kanye died. They are false and unfounded.
Oh my goodness.
2 days ago.
So Megan Thee Stallion has sued Milagro.
Who?
She sued Milagro.
Oh, Milagro, the YouTuber.
Yes.
She sued her for what?
The story just got posted on TMZ, and it says Megan Thee Stallion is suing Milagro, suing a content creator for allegedly promoting falsehoods about her.
I'll be right back.
she is posting lies about Tory Lanez case and spreading deep fake porn. Deep fake porn? What the heck? The rapper filed a lawsuit against Milagro Elizabeth Cooper, an ex-user with nearly 30K followers, alleging she's routinely posted lies about Megan Thee Stallion while working as a mouthpiece for Lanez to promote a false narrative about shooting her. Among the untrue content Milagro has posted, according to Meg, a totally artificial video that the Stallion's lawyers claim shows star engaged in sexual acts. They say the video has caused Megan severe emotional distress, reputational harm. And this has caused me emotional distress, Ike, and reputational harm. No, I'm talking about me.
Yeah, no, I agree. I'm sure it did, but judges have qualified immunity. So, that part.
Let's talk about that.
Yeah, well, she's acting in her official capacity. She has qualified immunity. The immunity protects her from being liable unless she goes outside of her judicial functions.
Example.
It's like what the Supreme Court said about Donald Trump. He is immune so long as what he is doing is an official act.
Okay.
Yeah.
Okay. So my redress would just to be for her to rescind and clarify.
Yes, absolutely, and apologize.
And apologize. Absolutely.
An apology would be really nice. An apology would be nice and appropriate, given the falsehood of these accusations.
So was I present when Miss Sylvia got the warning? No. Question 2, was you present when the judge stated that she's no longer, let's see, let me see your question. Your entire sentence didn't come out over here, so I don't know what that means. Okay. So I wasn't there when she got I wasn't in court when that happened. Actually, I was never in court when she got sanctioned by the court. And I would say, no, I'm not gonna say this because people say, no, Mr. Barr, no saying that. But I just thought some of the commentary, even in that, was inappropriate. It had nothing to do with Darth. I'm about to put you out of here. So we told me, get over it. Don't tell me.
Now let's talk to Darth Vader. Pull him up. What do you do for a living, Darth Vader? Talk to us. Why do you think he should get over this already? I'd like to hear from you.
That's right. Should I drop the link in?
Yeah.
Let me drop the link in.
And be prepared to tell us what you do for a living.
Right. Let me drop the link in there for anyone that want to join this conversation. And you can talk about the case. And what do you think the significance is and how this will ultimately affect the coverage of the case? And anyone is invited here. I'm dropping the link here. I dropped the link. Oh, that's right. I forgot you was waiting there. KMB. I dropped the link. Okay. And I want y'all to come in and let's have this conversation. You know, let's don't be keyboard gangsters. Let's have a mature, respectful conversation. And you have an attorney here and a journalist here.
Darth Vader, you haven't been hearing about this for several days because it just happened yesterday. Didn't it happen yesterday?
Yes, it did. Because I've been hearing about this for several. Oh, you just trolled.
That's not possible. I don't think your audience really cares. But this is you're ill-informed. You haven't been hearing about this for several days. Let's just stop there.
It was 2. He said 2 days. It's in 2 days. You're lying now. It hasn't been 24 hours. What are you lying?
Right.
What are you talking about?
Yesterday morning. So we're just at the second day now. It's not 2 days solid. I don't know what calendar or clock you are on.
It's not 24 hours.
Right. We just hit 24 hours because it's 11 o'clock now. It's almost noon.
No. It happened at one something.
Oh, it was the afternoon? It wasn't morning?
No,
look at that. I don't even know what time it was. Yeah. Look, so it hasn't even been 24 hours.
Now he says 1.5. Darth, 1.5 is not almost.
No, it hasn't been 24 hours.
Right. 1.5. Get at it. I dropped the link.
Is in the chat.
The link is in the chat. Do I need to? I'm a. Okay, so
So, Darth, what do you do for a living?
Right. She asked that question twice already.
I have.
No. You don't have to be an attorney. You don't have to be an attorney.
When you ask somebody what they are and they tell you what they aren't.
I'm not an attorney. Right. She asked what you are.
That is a failure. You must be a really good communicator. I'm being very facetious when I say that.
I'm a commercial real estate owner and developer. Okay, so you have some common sense here. So
okay, so let's talk about that. You're a commercial real estate owner and developer. Would you say, Darth, that your reputation in the industry that you work is important?
It's a yes or no.
For instance, if I thought that you were a shady
contractor,
real estate guy who hired contractors who use substandard material, if I thought that of you, that was your reputation, do you think that would affect your ability to be effective? I think the answer is yes. So that's why we're spending time on this, because right. Dennis deserves at least a day or two, if not more, to defend his livelihood. That's all he's asking for. Absolutely. And I don't think that's a lot. And if it is, then just come back tomorrow. Right. And hopefully we'll have moved on. And hopefully we will have moved on.
And go touch some grass. Go ahead. Go touch the grass. It's a world outside of the internet.
Right. Just kindness is free.
Politic Graham, what's up?
Naptown K, you want some of this smoke too? Dennis sound like he's crying. He should be crying. Dennis isn't entertaining at all unless he's with someone else. I'm new to your channel and thinks that you are way more entertaining than Dennis. Oh, but but we're on together right now.
Right, we together. Right?
And I get that. So Naptown, you could leave and come back when I'm on by myself, or if you're not going to contribute or have a question or even a criticism, I'm open for all of those things relevant to the subject.
Right.
Then please
skedaddle.
Bow out. Bow out.
We have politics. What's going on?
Hello, you guys. I couldn't believe what I just saw.
What?
I could not believe that what you have posted.
Yes.
I'm just in complete awe. What is going on?
That's what I want to know.
What shocks you about it?
No, because it just seems as if this whole thing is just chaotic. It's unorganized, and now we're trying to just blame anybody that comes into the room just doing their job. This is your job. You are a reporter. This is your job. So what are we doing? The thing is, and I'm just going to be very just blunt. I'm not going to curse. But she needs to focus on if she's going to have a mistrial and stop playing these games, because she's pointing the finger at the wrong person, because you're not the one on trial. You're not the one that's detained. And the last I heard, you don't work for no district attorney office. Just being honest. So my prayers goes out to you. My prayers goes out to all of the co-defendants in this YSL case. It's just astounding. And I want to also add to this. I don't know if these plea deals are going to be a benefit to anybody, because the plea deal that Mr. Nichols made, I don't know if you guys talked about it.
Not yet.
Not yet.
Oh, don't talk about it then.
No, go ahead.
No, go ahead.
Bust it open.
Well, the plea deal that Mr. Nichols made, I don't think I think that's a sit-up, because that's something similar that Young Thug brother had. And then when he got out, he ended up getting in trouble, and now he's, back in prison. So I think when it comes down to plea deals like that, a 20-year sentence with 7 years to serve and then 2 years served, and now he only has to do 5 years. I think that's a setup. Why? Because with Nichols, and I discussed about it, with some people before. With Nichols, and I don't know if you guys looked it up, with him, he comes from a quite some humbling background.
Mm-hmm.
And
Yeah,
it's like,
yeah. Mm-hmm.
So my question is, did the system fail him?
Mm-hmm.
Because people really bashed me when I said that, because they was like, well, you do the crime, you do the time. But my thing is, if his mother passed away when she was in prison, his dad got popped by Atlanta PD, okay, when he was just 4. I'm just gonna be honest. He didn't have a mother, he didn't have a father. I mean, it's the grace of God. He's still breathing and living and talking to say his name is Mr. Nichols. So so it's like, it's kind of just wow, all this is going on. And the judge, I think she's frustrated, and she's pointing fingers out at the wrong people right now.
At the wrong people.
So I just want to just say that, and you know what, you keep doing what you're doing. You're not doing anything wrong.
I didn't think I was. I'm not going to second guess myself, but I don't think I was. All right, I'm sorry. Not this other guy was up here. Did you leave?
Testing. Did I mute myself?
No. You here? Okay, hold on. Let me bring him up real quick. He's here. Hey, what's going on? KMB Parlay. Jesus. You're unmuted. Oh no, you.
Am I muted still?
Nah, my bad. Hey, good afternoon. I mean, good morning, everybody. I didn't mean to intrude on y'all. I'm just trying to make sure I was in here straight. But Mr. Byron, Miss Al-Shabaz, I'm in Chicago, so it's the morning still for me. So
that's right. Okay, Chi-Town.
But yeah, I mean, and I'm sorry I didn't interrupt you. I just let y'all finish, and that I got some questions for you.
You good? Go ahead.
All right. So my first question to you, Mr. Byron, is were you not aware that the judge put in a warning to everybody when Miss Sylvia got reprimanded the first time, or her Rule 22, when she was making nicknames of the jurors?
What should I have been aware of what? What part?
When the judge reprimanded Miss Sylvia for giving nicknames to the jurors, she gave a warning to all the media that day. Were you there that day?
No, I wasn't.
Okay. The second question was, were you aware that the judge also said she didn't want no recordings of the bench no more, and why that was done?
Of the bench? No, what she said was, when
she said no more bench recordings.
No. So, and that's known for anyone who had a Rule 22 in the courtroom knows that when the judge leaves the bench, you don't record. That's 101 for those who have been holding the Rule 22. You don't shoot the bench. Once the judge walks off, it's not a official proceeding until the judge comes back on. So it kind of pauses. So I don't do that.
Can you hear me?
I can hear you.
Okay. My mic went out for a minute.
Right, I think I answered your question. So yeah.
No, you answered my question. So when there's a picture that surfaced, right? When your picture surfaced, right? I think that's what caused this all. And then also Miss Sylvia, she was also caught in her own right as well. And I feel like you shouldn't be so upset about it though. You know what I mean? Like, this is what the prosecutors been wanting to do. They've been wanting to limit the media. You just a pawn in their game. And it's just unfortunate that you fell right into their hand. And we talked about this on Twitter. You let a sergeant give you an order when a general told you not to do something in front of the ops, and you expect a different result. and you know this,
No,
right?
well, listen.
But the pictures you're talking about are stills. They're not recordings. They are not the subject of this order.
But listen.
But listen
When you take a picture, I understand what you're saying. The picture, you said so when you take a picture, right? You capturing a moment in time, correct? You're making a record of time. You're recording that moment in time, are you not?
No.
They're getting you on it. Yeah, you are.
Not according to the court. It's a recording. Recording devices, I think, are limited to things that capture recordings.
I get what
a recording
I understand what you're saying.
A recording is anything that can capture a moment in time. You took a picture. Now listen, you took a picture in front of a prosecutor that can be misconstrued. What?
False. That's false right there. No prosecutor was in the court. He's in front of a prosecutor. I want to clear that up because you weren't there. So don't talk like you got the facts.
Oh yeah. And you totally right. And I do apologize. This is just a heated conversation. That's healthy between men.
We don't need to be heated.
It does need to be heated because it's really one. It's an infringement on the First Amendment. I do think you have a lawsuit on your hands, but you just have to play. You can't. I just feel like you're going about it the wrong way, and that's just my personal opinion. If I was in your shoes, instead of being outside, instead of going inside the courtroom, now is your time to really start bringing people to the courtroom for you. You take one, now you got 50. And I just feel like that's the way it should be. Like, and that's where other journalists should be rallying against you if they agree.
We talked about that.
You see what I'm saying? So at the end of the day, I feel like instead of saying, oh, whoa, I didn't do anything wrong, F it, stand your ground, put it down in paper.
Well,
you feel me?
You can't tell someone who's built a career over 20 plus years, 30 years, and tell them to say F it when someone takes an attack on your reputation. It's easy for someone who doesn't have the 30 years invested versus. Let me speak. It's easy for someone that don't have the 30 years that they invested in the time that I have invested in to tell me to just F it. I haven't F'd it this long. I'm not going to just F it now.
No, I understand what you're saying, Mr. Brodman, and this is where I feel like people like myself should be encouraged to take risks. You have 30 years of experience. You had the nerve to have some weird cartoon-looking lady named Megan could have called you a YouTuber.
Right, that part. Did you catch that?
Yeah, like I got mad respect for you. Again, you run you run a respectable magazine for years. You put mad black people on, and you in the courtroom, in the trenches, you gotta respect it. So with respect, iron sharpens iron. I gotta let you know when you're doing something that I wouldn't do as a man. When you've been reprimanded in court, you had your opportunity to speak, but you chose not to. You walked away. At that point, I'm thinking like you're plotting.
No, hold on. Plotting or planning is a difference.
And plotting and planning is the exact same thing. There is no difference.
No.
When you plot something out, you're plotting out a plan of action, correct?
Semantics. It doesn't
exactly.
matter.
It's the exact same thing.
But you were doing that. That's what he is doing.
But that's what I'm saying. I just feel like
I could be plotting too, but plotting has such a
negative connotation.
Right.
Why though? Why? Because we use it.
I like the plan.
That is by definition what connotation means, because that's how we use it.
Right.
If we're talking about the connotative definition, not the denotative definition. That's why
Respect.
I professor online.
No, respect.
Professor.
Thank you.
Hold on one second. I saw someone pop up here. I apologize. Don't go nowhere, my brother. Don't go nowhere. Stay right there. John Hip Hill, what's going on? Unmute yourself.
What's going on there today, Dennis?
Good morning. Good afternoon. Where are you calling?
Good afternoon, sir. From PA.
PA. Okay.
Yeah. So look, man, I've been following this trial for a while, and I got an intelligent question that I want to ask. And because we have an attorney in the room that's respectable and honorable there, I figured what better time to ask.
All right.
So through this whole plea deal, I've had one thing on my mind. right? It's the leverage of all the people in the courtroom. So we, as a journalist who's been doing this for 30 years and as an attorney, I'm pretty sure you both would agree that while everyone else may see the judge kicking everybody out of the courtroom and allowing them to deal in the courtroom is a bad thing, for the defense attorneys, it's actually probably one of the smartest moves they can make, because there's the strength in the numbers. While each attorney has a responsibility to each one of their own clients to do what is best for them, they know that all of them being in that courtroom and overhearing what's going on and being able to discuss it with the other attorneys and say, hey,
It's bad
they're
for
offering
business.
this person 15-5 and they're offering this person 20-7. And, maybe we have a little bit of wiggle room. But with the Nichols offer now out and done, I feel like it puts more pressure on the defense attorneys. And it kind of looked like that through the recording yesterday. All of the attorneys look just a little bit mad because they know once that first person makes that first offer, like you always see in the movies, the first person that gets a deal gets the best deal. Because what people are forgetting is that Nichols can now be given immunity and forced to testify. Just because it's not part of his plea agreement that he has to, he's going to be in jail. He can't dodge a subpoena. So they're going to be able to subpoena him. They're going to be able to bring him into the courtroom. And if they give him the same immunity that they gave Woody, then he's forced to testify. What are your thoughts on that?
Yeah, he's forced to testify, but he doesn't have any anything up over his head if he doesn't testify consistent to the way they want him to testify. So there's no incentive for them to have him testify, because they can't do to him what they did to the other defendants who were testing pursuant to their plea. So they bring him in under an immunity deal. He gets on the stand and he goes, I don't remember. 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 There's nothing they can do. They can't then ask the judge to re-sentence him for more time, right? Like they did with the other guy. So there's no incentive for the prosecution to bring him back, because he doesn't have to testify in the manner that pleases them. You following what I'm saying?
100%.
Okay.
And I think for the prosecutors, they got one more up on the board that they've convicted under this indictment. So they can say, hey, listen, we got, I don't know, what's the count of the people who've actually took pleas?
I don't know.
I think it's up to 6 now.
I think it's 7. It's 6 or 7 people.
Yeah.
Because altogether there was
28?
28 on trial.
Okay.
There's 12 still waiting to be charged.
Mhm.
There was 6 on this one.
One on the run.
One drop. So yeah.
We also don't know. So one of the other considerations as a defense attorney, I'll tell you is, and I'm also a former prosecutor, is these prosecutors do not want to be left trying this case with D. Williams's client, right? So everybody else takes a plea and they left to try this case for the next 6 months with one guy. So you got to understand also that there's that dynamic that, listen, everybody needs to take a plea.
So mute your mic if you're not talking. I hear some noise in the background. Mute your mic, please.
Yeah. Everyone needs to take a plea. You know what I'm saying? Or
nobody.
Or nobody. Right. So the fact
as
that
of
this
right
one
now,
person took a plea leads me to believe that there's going to be a whole lot more pleas coming.
To me, the only 2 pleas that I see coming, honestly, is getting the 2 quads out the way, or quays. That's the only way that I see the trial keep moving forward with a mistrial. Unless it's a mistrial. Paige has no choice.
The judge wouldn't be taking a plea on a case that she's going to rule a mistrial on. I think that would be unethical. I think it would be unethical for her if she knows she's going to declare a mistrial to take a plea
Well, that was Nichols who took the requested a mistrial. That's who it was.
Yeah,
I'm talking about
but-
I'm thinking about the judge though. I'm
Right.
talking about the
Yeah.
judge. I don't think she's
But
poised
wouldn't it-
to grant that
But they also
mistrial.
joined in that mistrial though. Like what's his name?
All of them.
The other Quay joined on it second after everybody.
Well, they have the
did.
Harvey rule in place, so everyone.
course.
Everyone's a part of the mistrial application, but
I'm just saying that he was the second one that stood up. Like, yeah, I have
Yeah.
to say too. Like, yeah.
Right, absolutely.
I also think that it wouldn't be unethical for the judge if, and again, we don't know what happens behind the scenes, so we're all just kind of speculating on
of course.
what ifs.
Right.
But the if would be if, let's say, Love ran over to Fannie Willis's office and Fannie Willis said, look, go back and tell the judge that as an agent of the court, if she grants a mistrial, we are stating right at this moment, we will rebring this case. It's guaranteed.
Yeah, that's
What? So,
of course.
yeah. So if they made that statement to the judge, then the judge wouldn't be unethical because the judge knows, okay, this isn't maybe I grant a mistrial and maybe they don't. They have now said it to the judge on the record, because everything you say to the judge is on the record, that they
Not
will
always.
rebring this case.
Not
Well,
all-
we all know the back room.
Right. A lot of that.
we all know the ex parte.
Yeah.
right.
I know sidebars that don't get recorded. That happens often too.
Right.
Right. Reporter doesn't come to the sidebar.
And sometimes it's intentional. And I always wonder why is it not taken down? Why are you not taking this down?
If you don't request it, the court doesn't seem to mind having these side conversations from time
But you
to
guys
time.
gotta understand, like them sidebars was being recorded. Like, I've been watching this trial since jury selection, like 2 years ago now. This is crazy.
Right, but the sidebars, even if they are recorded, they wouldn't be we wouldn't be privy to them.
No, I understand that, but I'm saying like before you wouldn't hear no audio or nothing like that, but you can at least see them talking.
Right now, that you can even do that. Right,
they took that away. You know what I'm saying? So
folks in this day and age know how to read lips.
Exactly, and they took that away because of Miss Love. The day that Miss Love got admonished badly, I think it was the day that she was wearing like red or something like that.
Right.
Not the yellow day. I'm talking about the red day.
Oh,
you know what I'm saying?
I shot the red or the yellow. I think I shot both.
And that's crazy. And she got admonished both them days, and you were present both them days, so that makes sense that she will go after you and Miss Sylvia, because Miss Sylvia ain't doing nothing but doing a little YouTube channel. Right. You know what I'm saying? And shout out to all the YouTubers out there.
Absolutely.
I watch all of them and you. So at the end of the day, man, I feel like it shouldn't be a woe is me moment. I think it should be, okay, we understand the objective. This is how we're going to counteract that, because you can't be a pawn on the chessboard forever. You're a reporter. You are the voice of the people.
That's right.
If you look at the chessboard, you like the bishop. You can move anywhere you want diagonally. You just got to get the people around you.
That's right. I agree with you. I love chess.
I agree with that as well. I think that was a beautiful analogy.
And I will challenge you.
You're a minor piece, Dennis.
I'm a
play chess too. I play. Yeah, the bishop is a minor piece.
Listen.
I'm just throwing that out there.
It's a minor piece.
Yeah, nothing can stop the queen.
Hey.
Right. Yeah. Okay. Let's get these rooks out.
Rook's not a minor piece. Rook is a 5-point piece.
I know. That's what I'm saying. We will stop you. You know.
Can I ask you guys a question?
Who that? Oh, there you go. You popped up.
Politics.
Go ahead.
My question. I want everybody. I'm really wondering. Do you guys really think Jeffrey Williams would take a plea deal?
Yes.
And if so, what would the plea deal be? Because
I think he takes a plea deal. He doesn't have
felony.
He doesn't have any priors, from what I understand. He could take a plea to something that would give him time served, right? So if they were to give him a sentence where, let's say he did I don't know how the way they do these, the way they did that 27. Let's say they do a 10-2, right? Where he takes a plea for 10 years, but he's got to do 2. He's already got 2 in. and he'll be on probation for 8 years, I could see him taking that.
I would agree with that too, and I think the problem is we, all of us non-attorney people. Sorry about that. All of us non-attorney people, we've been watching the trial and we kind of all have our own opinions, and they may all differ, but I feel like watching Nichols' plea offer, if you heard what Harvey said, Harvey's been the biggest proponent that his client, all throughout the trial, he said, my client ain't do nothing. I don't even know why we're here. We shouldn't even be part of this. But then come time to the plea offer, he says, hey, they already proved RICO and they proved he was part of that conspiracy. So he even kind of admitted like, hey, look, we've already proven this RICO count. And so I feel like no matter what, I think at the end of the day, the state wants everyone to at least plead to the RICO counts.
Right.
Yeah. Yeah. That is definitely what I believe. They want to at least get that RICO out there to give it some validity.
Yeah, exactly. And then you have the Shannon Stillwell. I felt like they let Nichols off the line, and they kind of even hinted towards it during the plea where they said, look, we have him on camera meeting up with Shannon. We have him following Shannon to the scene of the murder, and he was present for it. So he did conspire with him to at least go do it, but he didn't actually commit the murder. So we're willing to let it go for him. But I feel like for Shannon, he's the only person they can stick with that murder. Yeah. And if they let it go, then the Drinks family doesn't get justice.
Right.
And they're going to have to refile that one. So I think at the end of the day, Shannon, I understand we all have our own opinions, but I think at the end of the day, Shannon could be the lone holdout because he could go like, hey, look, I'm not copping to a murder because that's a guaranteed amount of time that I'm not getting out. But that might be the only person where they go, hey, look, you have to say you did this.
D. Williams's client is that, what's his name?
Lil Rod.
He already has a murder sentence for murder that he's serving, right?
Right.
Yeah, he already pled to his.
He is the least incentivized to take a plea in this case.
Exactly.
He is the one who is the least incentivized, not Shannon. It's him because he's already doing life.
I mean, but honestly, I don't think they proved anything, in my opinion. Like, this is all alleged. Like,
all this is alleged.
All of this is alleged. They didn't prove not one thing.
I would agree with you, but for purposes of a plea, right? When Harvey is trying to assuage the court in a way that this plea can go through without his client admitting to any violence, he's going to do some things and say some things so that he can get this plea through. His client has to legally and factually allocute. That means satisfy the elements of whatever crime he's pleading to. So he has to admit that those elements have been satisfied. Otherwise, the plea can't go through.
Exactly. And the one biggest thing about it being the RICO count is that you have to remember he kind of kept saying like, oh, he's not agreeing to the gang related charges.
Right.
But part of the RICO is part of that is him having to admit that YSL is a gang, because that's a part of that RICO count. So by him taking that plea, he's admitting that YSL is a gang. He's admitting he was a part of the gang, and he's admitting.
Yeah, but so we've got plenty of testimony from plenty of witnesses already that YSL is a gang. It's not a crime to be a gang. Not a crime to be in a gang.
But Monica made a point. He pled out to a drug, which is part of the RICO.
Right.
Right. The drugs.
Exactly. And his was weird because he got caught with drugs. He got caught with packaging for drugs. So they hit him with distribution. But now pleading it as part of the RICO, he is saying, I was doing that for the gang. And that's where that's where the RICO comes in.
Right.
So And for the state, that's another checkbox.
But I thought,
No, it's not.
I thought,
It's not
no, it's
another
not. I
checkbox.
thought
It's
Harvey
not.
straight up said this. He did this. He didn't do anything violent. He's only copping to the drug related charges for the distribution that they found on him.
Right.
So,
Right, and it's
I
not
mean,
a
Yes, but
checkbox because this evidence has already been before the jury, and
exactly.
none of this plea will be before the jury. None of it.
I think it's even worse. The jury gonna come back and see a person missing. Like, what
So
the
that's
hell's
my next
going
thing.
on?
So under the federal rules, which Georgia follows, the court has to give some sort of limiting and or curative instruction so that the jury doesn't speculate as to where defendants have gone. Right? Because when they come back into the courtroom, if they should come back into the courtroom, and one or more defendants are no longer a part of this case, they are going to wonder what happened to them. So the court has to instruct them that they are not to speculate as to where they are, and they are not to draw any negative inference, meaning they are not to think, oh, because they're not here, they must have took a plea, they must be guilty. Right? The court is going to admonish the jury that they should not draw any negative inference that these people are no longer in court.
And how much does the jury get paid each day to be there?
$25.
How much?
$25 a day. That's it.
So I have a little bit of an issue with this, and a lot of people have been saying this, and it really kind of got me, right? So I want everyone to kind of remember, and the lawyer in the room can back me up on this. When Glanville was, everyone brought this up, that, oh, they only get paid $25 a day. But if you remember, 3 different jurors all had problems with their job, telling them that they weren't going to pay them. And he said, Georgia law is that when you are on a jury, your job cannot fire you, and they must continue to pay you while you are on active jury. So not only are they getting paid from the court, but if they had a job, they are still being paid by their job. That's just the law.
I don't know that law in Georgia, and I don't know if it applies to every employer. It may apply to government employees. It may apply to employers that have 50 or more employees. You know, it may because if I'm a solo and I got one person working with me, and that person goes off to jury duty for 6 months, I could be bankrupt trying to pay them and still run my business without them.
Exactly.
Right? So I can't imagine that that's the rule for every type of employer, but I could be wrong. I don't practice in Georgia. I'm a New York lawyer.
100%. But we can also can make the inference.
Hold on. This is why I love having chats and smart people in the chat. C. Jackson says Georgia law only requires you to not get fired. That meaning that they can't fire you. It doesn't require that they also pay you. So they may keep you on.
That's what it is.
As an employee, but they don't have to pay you. Just your job will be there when you get back. That's
okay. Well, hey, look, if that's the law, that's the law.
Yeah, that sounds.
There you go. But I also feel like But I also feel like we can make this inference, right? How many times did we hear, or do we hear prior to jury selection, whenever anybody's talking about picking a jury, they always say we have to weed out those with that it would cause financial hardship.
Correct.
All of these jurors were told that they were going to be on this jury for over a year. It's not like this trial, when the trial started, they lied and said it's only going to be 6 months. They told them this could last for up to a year and a half. So all of these jurors had multiple chances to stand up and say, hey, I may be able to keep my job. I may not get fired, but I'm not getting paid. So I'm going to wind up, missing out on whatever the may be.
Well,
so I think
it's not just the jobs. These people have lives. People don't factor in their life to spend a year on jury duty, even though the judge may say that it doesn't sink in until you actually have to do it.
Yeah, you have to do it. Think about the things that you do when you're not at work. You want to pick up your dry cleaning. You got a doctor's appointment. You want to go to the dentist. You got to take your pet to the groomer. Like the shit that you do when they can't do any of that.
And the family emergencies.
And no
all of us
vacation.
that have kids, we know
Of
you get that
course.
phone call from the school about your kid. You
Gotta
gotta
go.
go. And
You
you
gotta
can't
go.
do that.
Or unforeseen expenses, right? Your car broke down.
Exactly.
Or you got a medical emergency that the insurance is not going to cover. There's any type of thing that could derail, your plans to do your civic duty. But I'm not sure what your point is with respect to the jurors. Do you think they're going to stop showing up?
No, my point was, I think people are playing too much into like, oh well, the jury, the jury is going to be mad because of this, or the jury isn't getting paid, so it's going to make them more angry. I feel like jury came into it knowing what they were getting into, and I could be completely wrong on this, but my man has been following since jury selection, so if you tell me I'm wrong, I will 100% say you're right.
No, I don't think
but
they was told that this case was going to last to a year and a half, because no judge can foresee this case being a year and a half. That means that
The judge
they were
didn't
already.
have time. Judge Glanville did say on the record.
I thought it was 6 to 9 months.
Yeah, he did say something like that.
He said 6 to 9 months. This case turned out to be almost twice that. So.
Right. They never came in thinking it was going to be the longest trial in Georgia. They never came in signed up for that.
Nobody signed up for that. So
true.
And for the jurors,
I have no life.
and that's what I'm saying. Like, as far as like the jury, like them, I feel like I'm just giving the grounds for my belief for grounds for a mistrial. The jury gonna come back. They already in the conditions that they in. They get removed they get herded in and out of the courtroom like cattle. They look like sheep coming in and out of there. It's bad.
Especially under Glanville.
Especially Glanville era. Glanville era was priceless. Uncle Phil was great.
The comfort breaks were the worst.
Uncle Phil was the greatest.
Think about day one opening arguments. What are you showing this for?
Man,
right.
Like,
what are you doing?
Like day one should have been a mistrial. Like I think so far I could be wrong, but there's been like 37, 38 mistrials.
No, it's about 50.
Motion.
50?
But you
50?
But you know, I'll say 50, but you know what though? And with the lawyer in the room, she'll attest, just like Steele said, you got to preserve your arguments. And we all know Steele is the #1 appeals lawyer in Georgia. Yeah. He's the #1 appeals lawyer in Georgia. So all of those mistrials, most of them came from Steele, because Steele knows, hey, if I don't make this now, I can't make it later in front of the Supreme Court or the Superior Court or whoever. So it's most of those is Steele going, hey, look, as a good appeals attorney, I know everything needs to be objected to. Steele would object to the color of your socks if he felt like there was grounds to it.
You got to preserve the record.
I feel like that's love. She the objection queen, man. Like,
yeah, she's not objecting for the same purpose. She's not objecting to preserve the record. She's objecting to obstruct.
Exactly.
She's objecting to interrupt your line of questioning. She's objecting to distract you from where you're trying to go. She's objecting to cue the witness on how to answer. You know what I mean? She's got a lot of different little reasons for her objecting, but it's not for the reasons it should be.
So this is my question.
Go ahead.
My question is, well, what was the whole reason of bringing in the guy? I think his name is Christian Eppinger.
Right.
What was the point of bringing him if he already has received a sentence of 64 years?
They brought him in to bring in his Twitter records. They brought him in because they needed him to get in his Twitter records, and they've said it the entire case. Both Glanville and Whitaker have said it. The defense has refused to stipulate to most things. So they won't just say, okay, yeah, we know there's a guy named Christian Eppinger, and we know you can bring him in to say these are his Twitter records, but we want you to bring him in because we want to question him. And then most of the times the questions.
So let me just respond to that really quickly, right? Because as a defense attorney, while we understand that there may be some judicial efficiency by stipulating to certain points of evidence, we also understand that the prosecution, they need to prove their case. It's your burden, and we don't want to help you. So in some regards, it looks like or feels like you're helping them when you stipulate to things. No, prove your case, because what happens is, and this has been my situation. There have been times where I haven't stipulated, and everyone in the courtroom is like, "What are you doing? Why wouldn't you stipulate? It's something so innocuous." And then they actually have to bring a witness on, and then that witness tells me some shit that they've been hiding.
Exactly.
And then you call holding the bag.
Right. So this is why you don't stipulate, especially with this prosecution team, who has been known for withholding evidence doing all types of things to the jury, making suggestive statements and
showing
comments,
pictures behind their back.
Yeah, all of that, all of those things that this prosecution is doing, like this.
So now
Exactly.
I thought about it, guys, because you know where I sit at in the courtroom, I'm literally right behind
the prosecution.
Love the whole defense on the prosecution table. So I see things with a camera and the big lens. They scared of Big Bertha. That lens zoom in to catch pimples.
Yeah, and you gotta know you a target, Byron. That's what makes me so upset, like, about this whole situation. Like, they didn't. You obviously can tell by what Love and what the prosecution was asking for from the judge. I don't want to have the camera at the judge's table no more. If the jury is coming in, it should be recording the jury coming in. They was late telling you guys not to put somebody on camera. They tried to blame you guys for putting somebody on camera when it was them on the live stream because of their Zoom. Like these are red flags.
I wasn't in court that day when that happened. I'm like, wait a minute. We thought it was the cameraman. And it was literally their monitors. So they switched the monitor.
Wow.
Okay. Show who.
Yeah, they try to blame y'all. Like, that don't make any sense. And when you say y'all, I have to say all the media. And that's why I feel like and that's why I have no respect for what Megan did, because you can't. Media is media. If you YouTube, you vlog, you're still getting the message out to the people. If you like to write it down, tweet about it, you still getting the message out to the people. Or if you do a video, because again, I do digital cinematography. That's me. I capture the story and bring it to the people. Right. You know what I'm saying? But don't discredit my art. Don't discredit the way I disseminate information. Absolutely. And when we do it amongst each other, it's disgusting. You know what I mean? So instead of like, no, it wasn't me, it was them. Like, let's just stand together.
I agree with you. And to your point, during the Tory Lane, and I have to just go there, during the Tory Lane's trial, it was a distinction made between journalists and YouTubers, and they too made that distinction. And now today we see this lawsuit by Megan Thee Stallion against she's going all the way in, because I got wind of this a while back that this was going to happen.
Blogger.
And now she's going in on
so is she suing in federal court or state court? That matters. Federal court.
But they
of course she's gonna sue in federal court, man. I'm not messing with Rock Nation. Respectfully, I'm not gonna say nothing disparaging. I love Rock Nation. Rock Nation is great. Jay-Z, awesome. I don't want no problem with you. You know what I'm saying? Thank you for the Super Bowl, my brother. Keep on pushing.
You made a good point.
The last one standing. I don't want no problem with Mr. Jay-Z. I know who Mr. Jay-Z got around him. Mr. Jay-Z's been around for a long time. You gotta leave Mr. Jay-Z alone.
Okay.
You got Miss Beyonce right next to him. We gotta leave them alone.
Yeah,
you know what I mean?
We're not bothering them. We don't want no smoke with them.
This is going to cost over $1 million to litigate. I mean, they're going to bring this. She's going to drag it into courtroom. It's going to be like Cardi B. And I can see this playing out, but I don't know.
My question is, what are they trying to get? What's their prayer for relief?
Yeah,
what would they like?
Yeah,
honestly,
because I don't know.
What she needs right now is record sales, because her album kind of like
I don't know if Milagros can help her do that.
I think that's gonna be.
I was about to say
what she's looking for. All publicity
I
ain't
think
good
she's looking for
you know.
the publicity. There you go.
Oh,
Yeah, yeah.
okay.
It's the publicity of
I'm
saying,
always
"Hey, I
asking.
sued and she was wrong."
Okay.
You
Well,
know what it's giving, to be honest?
what's it giving?
It's giving a junior version of Tasha K and Cardi B. That's what
Right.
it's giving. I'm just being honest because
Yeah, a little bit, but not really though. I mean,
No.
Tory Lanez, he got, like I said, every man got a right in court. He was found guilty, so right now he's a man that has to suffer that guilt. But he has his day in court of appeals, and they is gonna see he gonna get his day in court. So we just gonna have to see, man. Like I don't like speaking on, especially I don't like speaking on like situations like what they got going on, because especially when it has something to do with a man and a woman, and especially a black man and a woman, they already looking to like take that narrative and run with it. And the fact that we already divided as much, you know what I'm saying? Like we divided right now as people, like men and women right now is not seeing eye to eye. You know what I'm saying? Thanks to this election that we got going on.
Yeah.
But it is what it is. But we can't be ignorant. We got to see what's going on. We got to see through the BS and see the game that's being played. And that's the problem. And that's what happened in the courtroom. And they got you. They got you, Byron.
Well, they didn't really they really didn't get me because I wasn't going there every day now. So I got. But it's the point. What she did. Let's see. Then someone just sent me a message. Stand by. Okay, John asked that question. I just saw your message.
No problem.
I got my screen sweat. But thank you guys for coming up. Anyone has any more questions for Ike? Attorney Shabaz, Professor Shabaz?
Yeah, I just
No,
let you quickly. I don't think that
think
Tory
we all
Lanez the appeal has any merit. I don't think it has any merit. I don't, from what I'm reading, I don't think that his lawyers are making a claim of actual innocence in the appeal. I don't think they're making that claim. I think that part of their appeal is there should have been certain evidence presented that wasn't, which is not anybody's fault, but that defense who decided not to present that evidence that was available to them at the time.
Right. Bring
When
Quan
you
in.
make an appeal, right, you can't say, hey, there was evidence at the time, but I just chose not to use it. And you know what? It didn't go my way. So like, let me do it again. Because I this time I'm going to use the evidence. You know what I'm saying? Because no, that's not how the law works. That's not how it works. Were your lawyers overconfident? Did they think they had this case in a bag so much so that they didn't think they needed to present a defense? And they were wrong. Sometimes you miscalculate, right? And unfortunately, they don't go to jail for their miscalculations, but you do.
Yeah, I ain't never been to jail, and that's a good reason for that.
You don't want to go there. You don't want to go there.
I'm
I've been
never
to
gonna go
jail.
there.
I've been to jail on a visit.
Hey,
I
you
didn't like that.
Me.
I didn't like that.
Past one.
I get special privileges because I'm doing a council visit. So I don't have to go through the regular rigmarole. And I've been through the regular rigmarole when going on a regular visit. I don't have to go do that. But either way, it's not a pleasant experience.
But what you just said, but hold on, Byron. I just got a question from Ms. Al-Shabaz. You just said that you feel like the appeal has no merit.
Yeah.
You feel like it has no merit for the state, right? Because for the defense, I feel like this is gold. Like once this trial is for the defense.
You talking about for Tory Lanez?
Oh, I thought we was going back for we was going back to the Young Thug thing. We had
YSL. Oh yeah. No. I think so. I think if they somehow eke out, and I say eke out a guilty verdict, it will be absolutely overturned on appeal.
Most definitely, it's too many grounds.
I 100%
so that's another
agree.
consideration.
I think there's too many.
Hang on, guys. There's another consideration for someone who is taking a plea or thinking about taking a plea, right? Because if you are going to wait for the appellate process, that means you are willing to sit in jail until that process plays out. That is a huge prospect for a lot of people and their families. So I say to you, as the defense attorney, I come to you, here are your options. You can take this plea now, and I might be able to get you out in the next now to 6 months, right? Or you don't take a plea. We finish this trial. You know that you didn't get a fair trial. It likely will be overturned. It can't guarantee you, but it's a high probability it'll be overturned. but then they might want to try it again. And if they do that, you will sit in jail for the length of that whole time. That could be years.
I'm not trying to do no
So
Just
you know, a
Mercy
lot of
movie.
people don't really understand what these people are faced with, what their prospects. It's not like they have a bail. Things are different, and you have a different approach to your case when you are at liberty. You can make some different decisions, right? Because you can still work, you can still provide for your family, you can't do any of those things when you are incarcerated. You can't even fully assist in your own defense. You think Thug can really, really help Steele in the way he would be able to help him if he was out?
One day we making more money to pay his attorney and do more things.
That too, but that's what prosecutions want. They want these people to not be able to hire people like me, who's going to show up and kick the door in. They want that. So that's often part of the plan. Let's make sure that they don't have money to hire a lawyer. Let's make sure they don't have money to make bail.
You know, the prosecution was happy that 2 cameras out the courtroom. You know that.
That's a win, and that's the only win for the prosecution.
It is
the fact that they was able to get y'all out. The way, like that's 2
less eyes on the fuck shit that they're doing. That's right. Less eyes, less people to capture the mumbling, the showing of photographs to the jury impermissibly, all of the nonsense that they do at that table. All of it.
All that.
And hopefully after this trial, man, I hope you come out with everything that you was hearing behind the scenes, dog. I really do. Like, that's how you capture your word. Like, okay, y'all want to kick me out? Bet. On this day, this is when y'all messed up. You know what I'm saying? And just know, like, real ones know, like, what was going on. Like, people don't allow them to rewrite history, and that's you gave them a opportunity to rewrite history, man. And you can't stand for that.
I said this to the organizer for the protests in Atlanta. She was telling me how they gave her a section to where she can protest at. I said, they gave you an area where you can protest at? That's not really protesting if you protest it in the box they create for you. That's not protest.
Well, peacefully protesting.
That's peacefully protesting.
That's what peaceful protest is.
But that's not what America was bid on.
Right.
That's not what we was made on.
And you are relegated to a particular area. That's the peaceful protest. If you weren't doing a peaceful protest, you wouldn't got a permit. You just go out there. You don't ask anybody.
You can have a peaceful protest and still move in the areas you want to move in. That's my point. Don't let them create your design for your protest. You can walk. They put it on a corner in one block. And
it was sick.
Again, when you file for a permit to protest, then you should have put on there that we intend to move from this block easterly to this block and then northerly as a crow flies, right? You should put that shit in there. That way they know exactly where you intend to be.
So you saying the only way you protect yourself during a protest, like being a part of a peaceful protest, is if that protest was properly organized? That's isn't that the whole like premise against the protest? I don't think people who go on strike, they gotta.
Right. I get your point.
Strikes are organized as well. Strikes are well organized.
Yeah,
they organize within the people, but they're not going. They're not going where they're telling them where to go.
They're not getting advice from the ops.
Yes, they are. Yes, they are.
We're talking civil disobedience, right? And so I get it. If you're going to engage in an act of civil disobedience, then you should expect to be arrested, and you don't need a goddamn permit to do that.
Right. Exactly.
That's a different thing.
The question is, were they prepared to do civil disobedience? Mm-hmm. How does that look? And knowing what Rice Street looks like now,
protesting without a permit.
Yeah,
protesting in the places where you say they were, out of those places where they were corralled away from. Right. That's an act of civil disobedience.
Exactly. And even to your point, when you see someone strike, like let's say, you see someone walk off the job and they decide that they're going to strike. If you ever watch it from the beginning, you will see the police show up and go, hey, we're not trying to infringe on your right. But you're blocking the sidewalk. You need to let other people walk through. So if you just move back, we'll let you do whatever you want, as long as you keep it so that other people's rights aren't infringed.
Right. You can't interfere with traffic and things of that nature. That's what brings the cops. Right. You interfere with nature. You are traffic. You're blocking businesses.
Service. Yeah.
Things of that nature. I get that. But that's the whole
I
point.
do know. The
point of civil disobedience is you want to cause a disturbance.
There was a strike at the ports, right? There was a strike at the port. I think it lasted like maybe
5
a
minutes.
day and a half.
It was 5 minutes.
You know what I'm saying? Like, I think every time. That's what I'm saying.
It was enough to get people out to buy paper towels. It was enough to affect your Pavlovian response. It was enough to do that.
We're responding quicker now at post-pandemic.
Exactly.
Ike, I meant to ask you. Excuse me, guys. I meant to ask you. You said you have you ever taken that bus ride, or not the bus ride? Yeah, the bus ride over to the Rikers Island.
I can drive over. I have taken the bus. But I also can drive as an attorney. I get a pass to drive over that bridge when
to the actual jail.
So yes, the answer is yes. I've been both on the bus, on a public bus, and I have driven.
And being on that bus in the wintertime is something else.
Well, let me just say, I'm a native New Yorker, and I grew up in a tough neighborhood. So back in the day when I was in my date drug dealers phase, yeah, I was on the bus regularly on the VI to Rikers.
That's the visit.
You don't know my story. Shit, it's been a long and windy road. But yeah, I have been on the bus. What's your question, Dennis, about the bus? That is cold.
That's cold. But then, how was that experience versus because I don't know personally, but Atlanta, traveling over that bus over the bridge, and people don't. When you look at Rikers Island versus Fulton County Jail, it's like this is like Attica. It looks like Attica or
okay. See, I don't know. It's Fulton. I don't know what Fulton County Jail is, but Rikers is an island. That in and of itself should tell you, right? It's an island, and at any given time, I think the capacity is 10,000 inmates. It's not a nice place. You don't want to be there. You don't want to have to go there.
Is that where they're talking about sending Diddy?
No. Rikers is a city facility. Diddy's in the feds.
Federal.
Yeah, he's in a federal facility.
He's in a bad place now, but
with Tekashi 6ix9ine gonna be in the same spot.
Well, they just they are currently at the MDC where Diddy is. They are currently now doing a whole investigation into whether or not prisoner death, drugs coming in through guards, different type of paraphernalia coming in, fights. So they're doing all these investigations now in an effort to make the jail safer. And I think that that's directly in relation to the argument that Sean Diddy's lawyer is going to make at the next bail application, which is going to include that the MDC is a facility that's not suitable for anyone. And so that should be a factor the court should consider in his release.
So outside looking in, do you think Diddy did it?
Did he did it?
I don't think it matters.
I mean, I think it do. And I'm gonna tell you from just outside.
You're asking an attorney, so I'm gonna I have to answer like an attorney. I have to answer as an attorney.
I got you.
Right. It doesn't matter. Right. So when it comes to the law,
like let's just say I was a juror in this, right? Just say hypothetically.
Okay.
I would have to weigh everything. I understand that Diddy has a lot of money. I also understand that powerful black men, unfortunately, do get targeted. I also do know that in the hip hop culture, I grew up on the tip drill video. So I can only imagine on the tip drill video.
Tip drill video. What's that?
Nelly, okay.
Tip drill, Nelly.
We're gonna go back. Let's
stop acting like you know what the fuck he talking about.
I know what tip drill.
Hey, we know exactly what
right now.
But anyway, that's the era that I grew up on. So that's hip hop, right? So that's what they've been depicting. So I can only imagine what the parties be like when the cameras be off.
Right.
This man had been hip hop for almost 30 years, 40
Right.
years. We watched seasons of people leave, and did he still be here? And the fact that he has rubbed shoulders with leaders, politicians, CEOs, just people that's not normally who look like us, that come from where we come from, and what I mean, because at the end of the day, man, he came from your area, where you at.
Right. So how does that inform you as a juror?
Me as a juror, I understand also the mindset of people nowadays. Like, people do stuff for a payday. You mean to tell me after you get arrested for this, we've all seen what he did with Cassie. That is unfortunate. But I've also watched What's Love Got to Do with It. I know that's something that happens. Unfortunately, domestic violence is a sickness in America, and unfortunately, Diddy was bit by it.
Right.
That's why I thought, right, when there's a crime of passion between partners, you know what I mean? There is some leniency as far as the law. That's what I thought. Right?
What do you mean leniency?
Like, the law looks at it different. Like, you can't, like, instead of first degree murder, it would be like second degree murder, because it's a crime of passion.
There could be some mitigation. There could be some mitigation. Yes, there could be some mitigation
because they was in a relationship. So at the end of the day, like, okay, we can, outside looking in, we can say that Diddy is a bad dude, to be like, he needs help in counseling to help with his woman beatingness, right? That's wrong. We should not be putting our hands on women like that, period. Unfortunately, we've seen that. So after that happened, then now the investigation is going on. At the same time, it was an election. The same time Diddy started the voter die, whatever he started. You know what I'm saying? Like, Diddy was a big dude in politics. So you mean to tell me after all of this, now they get him? Now they decide to get him? It's like they wait and choose just like, I feel like the same thing with Lil Durk.
So
Lil Durk just got the key to the city.
Let me just say this. Prosecutors have the leisure to bring charges whenever they see fit. Whenever, so long as those charges are brought within the statute of limitations. That is the only constraint that they have. They have absolute
they have
discretion.
the keys to bring justice, period. So you mean to tell me they have the keys to bring justice? If they choose not to,
they always have.
As they see fit. So
as they see fit. That's always, that is one of the things
that if you got a corrupt justice or a corrupt prosecutor, is that, man, that's a whole nother conversation.
So KMB, it's no so if you got a corrupt prosecutor. When you have a
thank you for correcting me.
When you have a corrupt prosecutor, yes, they can decide, I will prosecute these people. I will not prosecute those people.
Right.
Yes,
they do it every day.
It's within their discretion. And they do it all the time, which is why people that are black and brown people are overrepresented in the criminal justice system. That is a function of choices being made by prosecutors. People talk about the numbers. How the fuck do people think these numbers happen? There are people behind the numbers making decisions that result in black and brown bodies being disproportionately represented in the prisons. And this system is not broken. It's doing exactly what it's designed to do.
Right. Hold on.
Right. So, and let me just say this. Diddy is not charged with domestic violence. He's not. He's not charged with domestic violence.
Some wild stuff like kidnapping, trafficking,
some other very serious charges. And I'm still not clear. I want to come back to you though. I'm still not clear on how the list of things that you gave us, how that shapes your vote as a juror. Did that mean that you could not find this person guilty, or you could not find him not guilty?
Again, I would have to hear the case. I would literally have to hear the case.
So then you're no different than any other juror.
Right. Because at the end of the day, right, when you say trafficking and what they're describing as trafficking, I don't see, like, that may not be trafficking to me, because you choose to pay somebody to come out and party with you. Like,
Okay, so let me
like,
explain
that's
to you how
crazy.
jury duty works. It doesn't matter if it's trafficking to you.
It's what the law
It
says.
matters. Yes, it matters if it's trafficking under the law, the definition of which I'm going to give to you.
Please do, because
And
this definition is wild.
No, this is what happens when you become a juror. You don't know when you swear to take the oath. You don't know what the instruction will be from the court at the end of the trial. You don't know what that instruction is going to look like. You take an oath that you are going to abide by whatever the instruction is, even if you disagree.
Exactly. And we haven't gotten there yet in the YSL trial, but that's something that's come up a lot, where they go, hey, look, we have to tell these jurors how they're going to find, this RICO count. Right now, us on the outside, we read the statutes and we read, what we can find. But the judge is actually going to sit down and tell the jurors, okay, hey, these are the 3 things you need.
Yes.
And this, let's say trafficking was one of them. They would give a definition and say trafficking is, let's say providing any compensation and moving someone across state lines for the sole purpose of engaging in sexual activity. So if they presented you with information that Diddy sent a message to a girl and said, hey, I'll fly you out here, and the reason I'm flying you out is for this sexual activity, that now meets that definition. So like she said, you're taking that oath that even though it may not be what your definition of trafficking was before you walked into the courtroom, you will listen to what the definition is and then apply the law the way it is written.
Let me give you an example. Let me see if I can pull it up real quick. Don't allow. I try to use this one. All right. So say, for instance, you were selected to be on a jury here in New York. It was someone is charged with selling narcotics, the sale of cocaine. You get picked on this jury and you sit down, and the testimony is this. This is for everybody. The testimony is this. Police officer observed person in the driver's seat, who was the defendant, hand over a tinfoil packet containing a white powdery substance to the person in the passenger seat. Cops moved in. Person was arrested. Person in the driver's seat was charged with the sale of a narcotic substance. Now, you don't know what sale means. You don't know the definition of sale in New York. You might think it means what traditionally and in common parlance it means. Then you get an instruction from the court. And the sale means to sell, exchange, give, or dispose of to another, or offer or agree to do the same. So no money exchanged, but under that definition, the driver sold cocaine to the passenger. And if you were a juror on that trial, under those facts,
I will recuse myself.
So that takes me to my next point. Jury nullification is a thing in which the jury says, you know what, you did prove to me that this was a sale, right, under the definition. But that shit just don't sit right with me, that I would charge someone who clearly looks like they were just going to party and he was just being generous and sharing his caring, right? Right? I can't get somebody that. I know what a drug dealer look like, and this ain't it, right?
Yeah,
so jury nullification is when the jurors conscientiously say, you proved that case, but we're not about to find this person guilty. No, and they vote not guilty.
And I think that's where a lot of people are getting lost in the YSL trial with the RICO, right? Like the RICO, there's really only 3 things that they have to prove. One, that the gang existed, right? And is that a gang existing is not illegal. 2, that you join the gang. And again, joining the gang is not illegal. But the third prong of that is where people are missing. that one or more people conspired to commit crimes in furtherance of the gang. And I felt like a lot of the crimes that they were bringing up, people just didn't know. The prosecutor didn't do a good job of connecting the dots, but I also feel like it was still early in what they considered their case, even though it's been going on for 9 months.
I think
they need to prove overt acts, at least 2.
Exactly.
I think they need to prove at least 2 overt acts.
Exactly. And I feel like people were like, well, why are they showing these 2 people got into a fight at the club? Well, if they can prove, hey, look, I got into a fight and KMB jumped into that fight because it was against a rival gang, and we did it to defend our gang's name. Well, that was in furtherance of the gang. Even though it was just a fight, me and him got into a fight with 2 other dudes. If they can prove that it was in furtherance of the gang, that meets that RICO. That now becomes part of it. So even though to us on the outside, it seems like it's just a fight and it shouldn't have anything to do with this case, it's the underlying things of, well, it was against another rival gang. They were defending their territory because, like Woody said, he in there every Monday. If gang showed up on a Monday, I got into a fight with if gang because they knew they shouldn't have been there on a Monday.
Right, but it just seems like a stretch to me. It seems like there are a lot of standalone acts that they have just rounded up and are painting with a very broad brush. Saying
and I don't
that
think
these
that's
things
legal.
were done.
And that should be legal.
And I feel like they could have made this case because look at it like this. Diddy got hit with RICO. Diddy's hit with RICO right now.
3
right?
counts.
Yep. He's hit with RICO right now. We all listened in when they said, what did Diddy, what did the prosecution say? How long was their case going to take? And they said 6 weeks. We can prove RICO in 6 weeks.
Yeah.
But you got YSL where they need 6 to 9 months, and now it turned into 6 to 9 years.
They need 6 years. They need 6 years. I agree, Jay. I think what my next point after the standalone acts that I think that they are bringing, that they are not in furtherance of any gang activity. They're in furtherance of these individual, whatever motivation they have seems to be individual. Right, doesn't seem like they're in furtherance of anything else. It's like, it's like you decided to rob somebody because you were short that day. It didn't have anything to do with why.
Exactly.
That's like saying the blood in California killed somebody. Now all the Bloods is a part of that RICO because that don't make any sense.
Exactly. And the problem is, I think this whole trial would have gone a whole lot smoother if they would have stuck to 2 things. They could have stuck to the IF gang connected shootings and the YFN connected violence, because they brought on 3 witnesses who said, look, all of these shootings happened. These people were involved, and it was his family, then it was his family. So that shows that it was a gang shooting.
Back and forth.
And they retaliated because they were part of the same gang.
Right.
So that's
not what they proved, though. What they proved so far to me, looking in, is that all of this started over a female. That's all that they proved to me.
But not the retaliating shootings of people's houses, and that's what you got to remember. Look, if all this started over a female, you're not shooting up my grandma's house because of a female. You might shoot at me.
If you shot at me and you miss, and I find out that you at your grandma's house, what? What do you mean, bro?
But here's what happened.
Real life, bro. Let's talk.
But here's what
happened.
Okay, so here's what happened, right? So now you said my grandma. Why you shoot at my best friend's grandma? Is it because me and my best friend are in the same gang?
Because y'all's at the same house.
But
I know you frequent there. I got you know what I mean?
But that's where that gang statute comes in now, where now they get to say, well, wait, he only shot at his grandmom's house because his best friend is part of the same gang. So now it's a gang shooting. Or else you would have just kept it to my family. The moment you moved on to somebody else's family, now it's...
Yeah, I understand what you're saying, but that's not what they're...
I'm not saying I agree with it. I'm not saying I agree with it.
Proving to me, and to me, what they have proved is all of this started over a female.
Well, that was the...
and then once Lil Woody got beat up, Lil Woody is his own entity and issues. I feel like that's his own entity. He his own person, and he was just bitter at one point in time in his life. Thank God he repented. You know what I mean? Good for that man.
But the
But
problem was it wasn't just Woody, because the story was, and 3 different people told the story. Woody got beat up, but then 3 other people jumped in it to defend him. And the people who jumped in it on the other side were all If Gang members. And he
so
was,
John,
and all the people on his side were
me and
YSL.
you are in the club. Me and you are cool.
Mm-hmm.
You getting your ass whooped in the club.
Yep.
I see that you getting your ass whooped. I go to help you. Now I'm in the gang. Me
But
and you are in the gang.
No. But that's where the proving that the gang exists and proving that you were a part of the gang. What if the day before me and you decided to say, hey, we John gang. And now we both put it on our Twitter. Now, yeah, you're part of the gang. And that's what they had to prove beforehand, was that all the people that helped him claimed YSL. See the difference?
Man,
So
being
what
an employee
is
and
connect, hold
claiming
on, guys.
YSL is different.
What is connecting Doug to the acts of these various individuals, other than like there was a phone call made while he was in New Orleans, and they were in Atlanta, the bus shooting. That's not even connecting Doug.
I'll be honest with you, okay? And this is my own personal opinion, and if nobody agree with me, I'm perfectly fine with that, right? I feel like this whole case would have gone a whole lot better because I feel like Thug insulated himself very well. His sister had the phone that made all the calls and called all the shots. If you follow the whole trial, her name keeps getting brought up in connection with the phone that's in New Orleans, the phone that's in Miami. Wherever Thug goes, his sister is with him. And the phone that they're trying to say, look, this is Thug's phone. This is the one that after this shooting happened, they called this phone. Well, this phone was in the sister's hands, and it's in the sister's name under the business. So I feel like what connects him to all of this and they haven't proven it, is the connection to his sister was right there with the, let's call it, we all know you keep 2 phones, one for the plug and one for the load. So one phone was for business, the other one was for the streets. But the one that was for the streets wasn't his. So I don't think they connected Thug to all of it. The only thing they can say is that, look, he did claim he started YSL. So he did claim that he started the gang. So they got him on that. But like everyone has said, it's not illegal to be a part of a gang. It's not illegal to start the gang.
He can start it, but he can also remove himself early on. Like, listen, hey, I'm going. This is what I do now. You guys want to keep up the name, and you want to still.
And that's exactly what happened. Like, you can't. And this is what's really disturbing, right? Like when you mix hip hop business and the way hip hop moves, because I mean, Byron, you can attest to this. Like getting paid from promoters, getting paid to like from shows, having them conversations, being on the phone. Like there's a lot of things going on in the background that an artist has to take care of. And Thug had a manager, which is his sister. You can't, you know what I'm saying? You can't demonize what the manager is doing. Okay, if something he got phone calls during that time, that does not prove anything to me. You
exactly.
know what I'm saying?
Exactly.
But you have to put yourself in the defense shoes and then put yourself in the prosecution shoes. Why is someone so closely connected to him, his sister, not always, taking calls around the time things are occurring, and she's with him? Why is that happening?
And
man,
then,
I can tell you exactly why. When somebody die out here in Chicago, you know how many times my phone rings for somebody to let me know? I'm not a part of shit.
True.
So what does that mean? That doesn't mean anything.
And that's the defense perspective. The defense perspective is, look, he grew up with all these people.
Exactly.
He knows they're out there doing all this stuff. So I don't think any of that really connects them. But what I always say is like this, right? We all remember growing up, and we always had that one adult in our life who said, hey, be careful who you keep around you, because what they do will come back and bite you. So the problem was the moment he started YSL, and then they went off and started, and let's say the defense is, well, look, they went off and started a gang. I went off and started a record label.
The state has proven that Young Thug didn't start YSL. It was 3 other people.
Well, no, because Woody said it was him and Thug.
No.
Woody said it was him and Thug in the picture saying we started YSL. Two of the 3 founding members.
See, I thought Tick said something totally different. I don't
No.
think
The picture they showed, it was a picture.
Let me just say that the point of all of this is that there is someone who is claiming also to be a founder, YSL Mondo, who is not charged.
There you go.
He is
And
not
the thing,
charged, and
that's Fonnie's former client.
right.
There, and the thing
crazy
is,
That's crazy.
if Thug at one point said, "Yo, you guys are getting too crazy. You know what? I'm gonna go over here. I'm gonna go do the music, but you're my brothers. I'm gonna keep in contact with you. I'm gonna still try to help raise you up." And that's what Steele's been saying the whole time.
Well, that's why
it isn't that
Big Bro. They reach out to Big Bro and do something stupid. Big Bro, they just
exactly.
That don't mean he's involved. This means that they calling for him. They need, hey, listen, we done did some stupid. Can you loan some bread? Whatever. And he just
and I think he's telling them no, and I still think he's telling them no because
but
I
the
haven't
problem
seen $1
is,
go to any of these people that's been on trial yet. I've
but
seen
the
money go to
problem
Woody and get
is
taken back at the club. That's it.
true, but the problem is he also didn't do enough to separate himself from them.
Stand by, guys. Ike.
Yeah, I got to get out of here. Sorry.
Yeah.
Oh man, it was so good talking to you too.
I appreciate y'all and your input. And Dennis, keep the fight, man.
Oh, we're fighting. We're fighting.
Yes. Keep hope alive.
And let me be up there on the YSL trial, the YSL case.
Are they on trial today? Are they coming back today?
No, I'm gonna give you an update right now. Stand by.
All right.
You ready? Nothing's happening yet.
Okay. All right, family. It's your girl Ike here. You know I love you. I really do. Yes. Y'all have a great day. Be blessed.
Thank you.
Peace.
Yeah, man. Like I was saying, I think that Thug just didn't do enough to insulate himself from them. It was like, look, I start YSL, I want to turn it into a record label. Let's say Woody said, well, I want to turn it into a gang. I want to get the streets behind you. So Thug go off through music, Woody stay in the streets and get the gang stuff popping. The problem is Thug kept them too close. They all use the same name. So now you have this weird mashing between what was gang related versus what was music related. And especially when you have people who are in the streets doing street things, but trying to make it on the label. Now, when they say YSL, while doing something, are they saying YSL the record label? Or are they saying YSL? And the problem is that's where the defense is having their problem. They now have to try to say, well, no, this wasn't for when I said YSL on today, I was saying YSL the label. But when I said YSL yesterday, I was saying YSL the gang. So, but the problem was if Thug would have said, you know what, y'all keep the name, y'all keep it in Atlanta. As I go on to this music stuff, I'm going to call it something else. And he didn't do that. He didn't insulate himself.
That sound good, but nah, I don't see that being his problem.
The defense is not even trying to hear that. To be honest,
that's not even trying. That's not even a valid argument, bro.
But that's what the prosecution is making right now.
It's not valid, but it's not what they're trying to say that it's plausible based on how Young Thug is moving in his career. You know, and
I'm not saying they're saying it about Thug. I'm saying that they're saying it about all of the other people connected. Like when Moonsoon said, hey, look, when I was yelling YSL from 2014 to 2016, it was because I was part of the security team. So when I said YSL, I'm on the record label. But then in 2017, when we went and we did this shooting and I put YSL for life, I was talking about the gang. Well, how do we differentiate when you were talking about the gang and when you were talking about the record label? Make sense?
And that's why he's sitting there holding that 5 years.
Exactly. Exactly. And that's the problem that Thug is having now. All of these people, they all say the same thing,
I mean, but
right?
he's sitting there 5 years because he did make that distinction. You see what I'm saying? That's
No,
why
no, no,
he.
no, 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 no. He's sitting there for them 5 years because when they the whole thing for his extra 5 years that he's sitting on right now is because he said yes in the courtroom being recorded
He
on
doesn't have
is
an extra 5
YSL a
years.
gang.
He doesn't have an extra 5 years. What he
Well,
had
they
is
gave him the 5 years.
5 years from the time he took. The plea he
Yep.
took. Right.
So when the reason they gave that to him wasn't because thing, and honestly, I felt like it was deserved. You can't go into a court and say yes, yes, yes to get out of jail. And then now when they call you back in and say you said yes, you got to explain it. Go, well, I didn't mean to say yes. I meant to say no. But you said yes. Words have power and you got to live by your words sometime. And there ain't no stronger words than a contract you sign. And he signed that contract, and then I felt like his lawyer didn't do him any justice because his lawyer was like, oh yeah, I just didn't read that, thinking that was going to get him off. But that's what happens. Like even the lawyer admitted we didn't read that part of it, but you agreed to it in the courtroom when they were reading it to you, and you told the judge yes.
We can all agree at this point he breached his agreement no different than you breach a loan or you breach a whatever thing he signed to say you're going to follow those terms. He breached it, and it was almost insulting that the lawyer would come back in and then try to re-explain his interpretation, and not even when it's time for revocation. He only points out to factual knowledge with number 8, but he ignored
Exactly.
the ones that he obviously testified to, and they set him up on that stand. They were lining him up when they put the lawyer on the stand. I said when it happened, are they lining him up for the big?
Yep.
And the judge said this is like perjury. But now, Judge, I'm not really riding hard for you no more. And that wasn't riding hard for you before. But Judge, I'm giving you the side eye.
Exactly. And the thing is, people try to compare Woody to Sledge, and I looked at that like no. Woody never said, "Hey, I didn't say this." Like when Woody got up on the stand, right, and they said, "Did you say yes that 3 or more people that there are 3 or more members of YSL?" And he just named 3 people. He said, "Yeah, I know these 3 people." They said, "But do you know anybody else?" He said, I don't know about anybody else. You said 3. I'm giving you 3. That completes that's what I said yes to. When they said, "Do you know anybody who's committed a crime?" He said, "Me. I know I committed a crime. I don't know about anybody else's crime." But you didn't tell me to tell. I wasn't saying, yes, I knew somebody else committed a crime. I was saying that I knew of a person. I'm a person and I know I committed a crime. So I answered correctly. Woody got up there and said, "I don't know. I don't recall. You can play whatever you want. I lied." And that's perfectly fine. Right. But when it came to the factual acknowledgments of his plea, he accepted responsibility for every single one of those factual acknowledgments. It may not have been the way the state wanted it to go, but he said what he said.
King of the finesse.
Yes.
No, he didn't have no finesse, and that's a shame. Like
That's
why it's important. Who Mutu?
No,
no, Woody.
Man, I mean, Woody. He played his part, man. He had immunity. He could have said anything he wanted.
I said king. He said himself. He finesse. I say he's the king of the finesse. Come on, let's give him that. Give him the finesse of the year award. He finessed.
He couldn't have said anything he wanted because people kept forgetting that. Like I pay attention when people say the same thing and keep repeating it, because when somebody is repeating something, it's something that they really want you to understand. That is what they're trying to say. They don't care about anything else. It's the part that they repeat. And if you remember with Woody, even in the ex parte, the part she kept repeating is, "If we can prove you are lying about it, that is when we can take this away. If we can prove you're lying about it." So he couldn't have got up there and said, "Oh, I shot Buddy Boy on Thursday at 2:30." Because if they can prove you didn't do it, if they got a video camera of you at McDonald's at 2:30 on Thursday, now your whole plea deal gets taken away. And he finessed that, like I said, he finessed it with his words, going, hey, look, you said, do I know 3 people? I gave you 3 people. 2 of them might be dead, but that's on y'all to figure out. I just said I knew 3 people. You know, do I know someone who committed crimes? I committed crimes, and I admitted to be a partner of YSL. So there you go. You know, does YSL have gang signs? I know of 1 gang sign, and this is what it is. You didn't say that I had to know all of them. You didn't say that I had to know 14.
No, that's what I'm saying. Like Woody was able to do that with the immunity. Like that's
Yep.
what I'm saying. He was able to finesse because he had immunity and he had Judge Glanfield that had bowel issues and a dog. So
Yeah.
at the end of the day, like
What did you just say? Hold on.
He said he had bowel issues and a dog.
Don't do that. Don't do that. I got to come in there. But the dog was a little, no. The dog was a little troubling. I don't judge it, Glanville. I'm gonna tell you something. Sylvia told me in the very beginning there was a dog in the courtroom. I kept on telling there's no dog in the courtroom.
Yep.
But ultimately, it was a dog in the courtroom. They were lying to me. Not just they were lying to me. So like, why are you telling me there's no dog in the courtroom? You work here.
See, that's crazy. We knew that. I knew that as I was watching. The man said it the first day. He's like, "Hey guys, I got an attack dog. I'm a emotional support animal. Don't pet him. Don't try to feed him or anything." Judge Glanville was hilarious, man.
This is the dog was there from pre-trial. So, guys,
he was there for a minute.
Yeah, he was there for a minute. Guys, I want to give people an opportunity to come up. So I want you guys to stand by, please.
Yeah.
All right, so I'm gonna drop the link right now. If you want to come up, I'm gonna let you come up. I'm gonna drop the link again. You know, we thank you for my esteemed panelists.
Hey, Byron, I gotta go get my bread today. I appreciate you.
All right, is that
local Parlay Jesus? Okay, no, man, I do honest work. I work in the finance industry.
Okay.
Well, on my side time, I do digital cinematography. I got a Sony FX5K Mark II, always ready to shoot.
Okay. Okay. Where you located?
I'm in Chicago.
Oh, Chi-Town, because I know you too. Okay, Chi-Town. Okay, so you can pull up for me if I need you to pull up in Chicago anywhere.
Anytime for you, my man. Anytime.
Right. Okay, shoot me make sure I have your contact. Put it in the message because I might need you to do some camera work.
I got you.
All right, my brother. Appreciate you. I bet you don't know what I was doing. What's going on, ladies and gentlemen? What's going on? I was taking a comfort break, sort of. What I want to do right now is I'm going to put this. I'm going to check for the updates, and I'm going to put you guys in the. Just put you guys on hold. We got to do a little comfort break, and I'll be back. I promise. I really will. Peace.
On the beat. on the beat. On the beat.
Mic check 1 2. Mic check 1 2. Ladies and gentlemen, get in here. Get in here. Get in here. Put a 1 in the chat. Put a 1 in the chat. Breaking news update in the case involving rapper Young Thug. Ladies and gentlemen, get in here. I'll give you a couple of minutes to get in here. Get in here. Yes. We have an update. Ladies and gentlemen. We have an update.
Bully on the beat.
Ladies and gentlemen, make sure you guys are in here. Okay. Those who've been following me, I told you yesterday that there was another plea that had been negotiated. There has been another plea that has been negotiated. I spoke about this yesterday for those who have actually been following me. I don't know how many of you follow me. And I also reported that there's a plea tentatively being worked out with rapper Young Thug. Well, I just learned that there has in fact been another plea, and there will be an announcement in the court. Just waiting for them to set the cameras up. Make sure you guys are locked in here. I need to pull a feed, and let's interpret what exactly is about to happen. But there has been another plea, and we're just waiting for it to be announced in court. Ladies and gentlemen, I knew this was happening. I just didn't know when, but I knew it was happening. We got a plea deal. Ladies and gentlemen. Finally, a plea deal. And guess what? You wouldn't believe who it is. But we'll know soon enough. I'm watching my feed. Guys, stand by. Let me get the feed. Stand by. I can take you off camera. Get myself off camera. What it do, Thugga? What it do?
Do you understand this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 10 years to serve, commuted to the time you have served in this case? Do you understand that?
Yes, ma'am.
And do you understand that this sentence should run concurrently with the sentence that you are already serving for 19 SC 168236? Do you understand that?
Yes, ma'am.
Do you understand that the court does not have to accept this recommendation?
Yes, ma'am.
And the court can sentence you to the maximum on this charge?
I understand.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including the federal courts?
Yes, ma'am.
Do you understand if you are not in the United
One
States?
moment. Please repeat the question. Do you understand that the
enhancing
conviction?
sentence? That one, the one on enhancing sentence?
Yes, I just needed to explain a bit more what that means.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including the federal courts?
Yes, ma'am.
Do you understand that if you are not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would, and that this is true regardless of any advice by your attorney or anyone else?
Yes, ma'am.
Do you understand there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect your right to vote, your right to hold public office, your right to serve on a jury, your right to obtain a passport, your right to receive, possess, and transport a firearm, or the ability to obtain employment. Do you understand that?
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years.
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand if you went to trial, you have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify to remain silent and not incriminate yourself?
Yes, ma'am.
Do you understand that by pleading guilty, you are giving up the following rights? And after I say each right, I'll ask you to respond, okay? The right to trial by jury,
Yes.
the right to remain silent and not incriminate yourself,
Yes.
the right to confront witnesses against you,
Yes.
the right to assist of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at the trial of your case,
Yes.
the right to the presumption of innocence,
Yes.
the right to testify on your own behalf and to present other evidence,
Yes, ma'am.
the right to subpoena witnesses and compel the production of evidence,
Yes, ma'am.
the right to have the charge against you proved beyond a reasonable doubt,
Yes.
and the right to appeal if convicted of these charges at the trial.
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
With respect to indictment 22 SC 183572, how do you plead to count 1, conspiracy to violate the Racketeer Influence and Corrupt Organizations Act?
Guilty.
Is this guilty plea freely and voluntarily given with a full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you have 4 years from today's date to file a habeas corpus petition challenging the voluntariness and constitutionality of this guilty plea?
Yes, ma'am.
Do you also understand that you have 30 days in which to appeal your conviction based on your plea today?
Yes, ma'am.
And do you also understand that you have until the end of this term of court to file a motion seeking to withdraw your guilty plea?
Yes, ma'am.
Your Honor, if this case were to proceed and continue with trial,
Your Honor, evidence has shown and will further show that Mr. Ryan conspired with others to participate in the Young Slime Life gang through a pattern of racketeering activity, and multiple defendants and unindicted co-conspirators have committed overt acts to further this conspiracy, including drug sales, aggravated assault, and murder, also including social media posts asserting the violent nature and dominance of Young Slime Life, aka YSL. Your Honor, the court has been present for evidence regarding the February 23rd, 2019 homicide of Mr. Jamari Holmes, in which Mr. Ryan and YSL co-conspirator, Damon Blaylock, lured both Jamari Holmes, Bernard Mitchell, and Rodney Hooten to an apartment at 50 Mount Zion Road, which is in the Cleveland Avenue area. The evidence came out that during the course of that incident, that Mr. Ryan, along with Mr. Blaylock, emerged from the apartment complex, shooting at the vehicle which Mr. Holmes, Mr. Hooten, and Mr. Mitchell were in, shooting Mr. Holmes in the head. After this incident, a few hours later, Mr. Ryan is seen posting on social media, on a public social media post, saying that YSL makes the news. Right, there has been other social media posts in which Mr. Ryan has promoted or enhanced the reputation of YSL. Your Honor, the state intended to show further evidence that once Mr. Ryan was convicted of the homicide of Mr. Holmes while in prison, he continued to enhance the reputation, power, and territory of YSL. Specifically, when YSL co-conspirator and co-defendant Christian Eppinger was given a bond for shooting at an Atlanta police officer, Mr. Ryan, while on a contraband phone in prison, posted on his social media accounts, he flashed the YSL sign and stated, "We're coming to get you. YSL shit, free my N-word brisk, F the DA, the gangway, we catching bonds on this shit." Your Honor, this is the evidence that the state would have intended to show if we would have continued with trial. Given the current status, Your Honor, we've made an offer to Mr. Ryan for this community time served offers from concurrent with his current conviction, Your Honor. And I can approach with the documentation.
You may. And I wanted to just add one thing to the information about the different methods you have to file things after this plea. And that is that Misty Williams and Ms. Abbasi will represent you until either the end of this term of court or 30 days, whichever's later. And so they would be the ones to talk to about filing those things, unless either of them is permitted to withdraw before that time. They would be the ones to file those for you, okay?
No.
All right, Ms. Abbasi, is there anything that the defense wants to add to the record?
Yes, Your Honor. Your Honor, I have had the honor really of representing Mr. Ryan along with Misty Williams, who I'm quite disappointed she could not be here today for an important day. This trial has been exhausting for everybody, and that certainly includes Mr. Ryan, who has been going through the court system since he was 15 years old. We categorically and adamantly deny that YSL is the criminal, dangerous street gang, which it's been made out to be through this trial. We're actually quite happy with the record, which was established during the presentation of the state's evidence of the alleged murder of Mr. Jamari Holmes. This plea today, Mr. Ryan is making a decision which is going to be the best for his future, what future he has, because he's already serving a life sentence. Were he to be convicted and sentenced to additional time, he would remain in custody. As I stated, we think the record established will strongly support his appeal, and hopefully, when his conviction is overturned, we don't want him sitting in prison for something else. Certainly not for actions he took when he was younger, and actions he took which are largely a product of how he grew up. As I stated, Your Honor, Mr. Ryan was 15 years old at the time of the Jamari Holmes murder. You've seen through the text messages, he was out at all different hours, doing all different things, which I don't think anyone would want their 15-year-old to be out doing. And so that is where he was. And so he did adopt the people who were around him, the people who could support him, the people in his neighborhood who grouped themselves, calling themselves YSL. Mr. Ryan at no point was trying to advance a criminal street gang and their interests. He was trying to protect himself, being a young person, largely on his own, and this is where he's ended up. I would like to say that there's been some sort of rehabilitative function here since he was sentenced to prison. It doesn't appear that that has happened. As you've heard, some of his additional cases are within the prison system. It would be wonderful if some of the money spent on a case like this could possibly be invested in the future of people like Mr. Ryan, who go into custody at such a young age and who really then are not given the resources to make the changes that they really would like to make to have a productive future. With all of that said, I think Mr. Ryan has grown up a lot during this trial. He doesn't want to sit through this anymore. He doesn't want to ever be back in a courtroom ever again, Your Honor. He's heard about all sorts of incidents, which the 2015 crimes, he was 11 years old. Mr. Ryan's most sincere wish is to move on with his life, to put this behind him. And we thank the court for the opportunity to resolve the case in this way and not drag it out any further than it has been. He just would like to thank the court, Judge.
All right, thank you. And Mr. Ryan, I just want to make sure that you understand that this is ultimately, the decision is yours to make, not your attorneys. And I appreciate that both Ms. Abbasi and Misty Williams have been available in giving you legal advice and guidance, but it's ultimately your decision. Do you understand that?
Yes, ma'am.
All right. And do you, in fact, want to plead guilty?
Yes, ma'am.
All right. And you've had enough time to think about it and to discuss it with your attorneys?
Yes, ma'am.
All right. And Ms. Abbasi, have you and or Misty Williams talked to Mr. Ryan about the benefits and drawbacks of all of his different options?
Yes, Your Honor.
All right. All right. I find that there is a factual basis for the guilty plea to count one, the conspiracy to violate the RICO Act. Whatever the difference of opinion may be with regard to what YSL is or isn't, and what Mr. Ryan may or may not have intended, there is a factual basis that exists from the record as it already is in this case to support the necessary elements of the conspiracy to violate the RICO Act. And I have heard many of the alleged overt acts and the conspiracy evidence to advance the enterprise through a pattern of racketeering activity and to control personal property and money. And I find that the factual basis for that exists. And I am going to accept Mr. Ryan's guilty plea. I find it to be freely, knowingly, intelligently, and voluntarily entered with an understanding of the consequences of this plea. And I'm going to sentence in accord with the recommendation that both of the state and the defense have worked hard to negotiate here, which is a sentence of 10 years commuted to time served and to be run concurrently with the sentence that Mr. Ryan is currently serving. And certainly within the court's consideration is the knowledge that Mr. Ryan is at this time serving a life sentence for the murder of Mr. Holmes. And while I understand that that is on appeal right now, you know, those are the facts as they exist right now. So that is the sentence of this court. Mr. Ryan, at 20 years old, you have most of your life ahead of you, and I don't know what it is going to hold with regard to your appeal or anything after that. But whether it is more years in custody or whether at some point in time you see the light of day to the outside world again, which is very likely considering your age, as long as you behave yourself while you're incarcerated and do not continue to either commit crimes in prison or violate any of the prison rules. If you can be on the straight and narrow, then somebody your age, after serving some amount of time, is probably going to be considered favorably for parole. And you just have to keep that in mind, that you need to be looking out for sort of the long run and not playing the short game, but playing the long game so that you have a future in front of you still. So that is your sentence, and I wish you luck, and I wish that with further maturity, much like Ms. Abbasi has said that you have already exhibited throughout the course of this trial, that you are able to make better decisions and steer your life in a better direction. Thank you.
Thank you.
Mr. Matthews, are y'all ready? All right. You may. Yes, and I'm going to go ahead and, where's Mr. Foster? Give you these documents, and then this document. Okay. All right, so we already have the signed copy of the indictment. Mr. Huey and Mr. Ryan have both signed, so I have that already. Yes. Okay. All right, and Sergeant, if you can swear in Mr. Huey.
Yes. And Marquavius Huey.
Governor, we have just received the redacted document here, so if I can have an opportunity just to execute the.
Absolutely.
Thank you.
Right.
And Mr. Matthews, just so that the record is clear, I know that y'all are just now signing the, I guess it's still a, what, 5-page document? That this is not the first time you're seeing the most of what's in that document, correct?
Absolutely
this is
not.
right.
We've seen
So
this.
there were a couple of items removed from the sentencing acknowledgments at your request. Is that right?
That is correct.
Okay. And otherwise, other than that section 4, everything has essentially stayed the same with regard to the rest of the document. Is that correct?
That is also correct.
All right. And you and Mr. Matthews and Mr. Huey were aware of the changes that were getting made.
Yes.
All right. Do y'all need any additional time to look over the refreshed document?
We do not.
All right.
I've reviewed it and we are ready to
All
proceed.
right. Sounds good.
Okay, I have it.
No, that's all right. It's essentially the same. Okay, thank you. So you've got the waiver of rights and this separate kind of list of the charges and the sentences. Okay. And the indictment is with Ms. Rosser. I'm ready whenever.
Consider you please raise your right hand. Do you solemnly swear that the evidence shall give in the matter now pending before the court shall be the truth, the whole truth, and nothing but the truth?
Yes.
I think he already got sworn, so you're double sworn at this point.
Please state your true and correct legal name.
Marquavius Huey, MARQUAVIUS, HUEY.
And are you the same Marquavius Huey on indictment 22 SC 183572?
Yes.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
How old are you?
28.
And how far did you go in school?
12th grade high school diploma.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you were in this indictment charged with count 1, conspiracy to violate the Racketeer Influence and Corrupt Organizations Act, which carried a sentence of 5 to 20 years?
Yes.
Count 3, you were initially charged with armed robbery, which carried a sentence of 10 to 20 years or life.
Yes.
You were charged with count 4 and 5 of this indictment, aggravated assault with a deadly weapon, which each carry a sentence of 1 to 20 years.
Yes.
You were charged with count 6 and count 7 in this indictment, which you charged of possession of a firearm during the commission of a felony.
Yes.
And that carries a sentence of 5 years to serve consecutive to any other count in the indictment.
Yes.
You were also charged with armed robbery in counts 14 and 15.
Yes.
Also charged with aggravated assault with a deadly weapon for count 16 and 17.
Yes.
You were charged with hijacking a motor vehicle in the first degree.
Yes.
You were initially charged with possession of a firearm during the commission of a felony.
Yes.
Counts 19 and 20. You were charged with 4 counts of participation in criminal street gang activity, which were counts 21, 22, 23, and 46.
Yes.
And you were charged with possession of a weapon by an incarcerated individual, which was count 44, and possession of a telecommunication device by an incarcerated individual, which was count 45. You understand that those were your initial charges in this indictment?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes.
And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had an opportunity to go over this waiver of rights form with your attorney?
Yes, ma'am.
And is this your signature on this document on page 4 of this document?
Yes.
Have you had enough time to speak with your attorneys, Carrington Matthews Sr. and Carrington Matthews Jr., about all the facts and circumstances known to you regarding the charge in this indictment, including any potential defenses?
Yes.
Do you need any more time to discuss this matter with your attorney?
Nope.
Are you satisfied with their counsel and representation?
Yes, ma'am.
Do you waive formal reading of the indictment?
Yes.
Do you waive any defects, if any, with respect to the indictment?
Yes.
Is it your understanding, have you been arrested on all of the charges contained within this indictment?
Yes.
And Mr. Matthews Jr., are you aware of any other outstanding warrants for these charges?
We are not aware of any.
Have your attorneys advised you of the minimum and maximum sentence for each charge that you are pleading to?
Yes, ma'am.
Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court the following sentence?
Yes.
Let me tell you the sentence. As to count 1, which is conspiracy to violate the Racketeer Influence and Corrupt Organizations Act. The state's recommendation is 20 years to serve 9 years in custody, the balance of 11 years on probation. As to count 3, armed robbery, based on the negotiations, the state will reduce the armed robbery to robbery and offer a sentence of 20 years to serve 9 years in custody, concurrent with count 1, the balance of 11 years on probation. As to count 4, aggravated assault with a deadly weapon, the state will recommend 20 years to serve 9 years in custody, concurrent with counts 1 and count 3, balance of 11 years on probation. As to count 5, aggravated assault with a deadly weapon, the state agrees to null pros or dismiss that count. As to count 6, possession of a firearm during the commission of a felony, the state's recommendation is 5 years to serve, consecutive to counts 1, 3, 4, 14, 15, and 44 to be suspended. As to count 7, possession of a firearm during the commission of a felony, the state will null pros or dismiss that count. As to count 14, which is armed robbery, will reduce that to robbery, 20 years to serve 9 years in custody, concurrent with counts 1, 3, and 4, balance of 11 years on probation. Count 15, armed robbery, reduced to robbery, 20 years to serve 9 years in custody, concurrent with counts 1, 3, 4, and 14, balance of 11 years on probation. Count 16 will be null pros or dismissed. Count 17, that count will merge with count 15. Count 18 will be null pros or dismissed by the state. Count 19, possession of a firearm during the commission of a felony, will be 5 years to serve, 5 years to serve consecutive to counts 1, 3, 4, 14, 15, 17, and 44, but concurrent with count 6, and that will be suspended. Count 20 will be null pros or dismissed by the state. Count 21 will be 5 years to serve, concurrent with counts 1, 3, 4, 14, 15, 16, 17, 19, and 44. Count 22 will be null pros or dismissed by the state, as well as count 23 will be null pros or dismissed by the state. Count 44, possession of a weapon by an incarcerated individual, will be 5 years to serve, concurrent with counts 1, 3, 4, 14, 15, and 17. And counts 45 and 46 will be null pros or dismissed by the state. Do you understand that that's the state's recommendation?
Yes.
You understand that the total sentence is 25 years to serve 9 years in custody with a balance of 14 years. 9 of those 14 years will be served on probation and 5 years will be suspended. Do you understand that?
Yes.
Do you understand that the court does not have to accept that recommendation?
Yes.
And the court can sentence you to the maximum of each charge and can run those charges consecutively, one after the other.
Yes.
Do you understand this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including the federal courts?
Yes.
Do you understand if you are currently on probation or parole, your probation or parole may be revoked based on your entering a guilty plea today?
Yes.
Do you understand if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions without being subject to revocation for the balance of the sentence?
Yes.
And do you understand that there were several special conditions of probation that you must adhere to, which are contained within this documentation?
Yes.
And have you had an opportunity to go over each of these special conditions with your attorney?
Yes, ma'am.
And did you also go over with your attorney your sentencing acknowledgement regarding this plea agreement?
Yes.
And is this also your signature on this documentation with your attorney going over each of the sentencing, each of the special conditions of probation.
Yes.
And do you fully understand the special conditions of probation?
Yes, ma'am.
Ms. Hilton, can you pass that document up to the court, please? Thank you.
Did you want to review before I continue? Did you want to review before I continue?
No, that's fine. Go ahead.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Do you understand that you are not a United States citizen? A guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would, and that this is true regardless of any advice by your attorney or anyone else?
Yes.
Do you understand that neither the court, your attorney, nor the district attorney's office has anything to do with parole, the Department of Corrections, or the Board of Pardons and Paroles, and no one can guarantee parole no matter what anyone has told you?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect your right to vote, your right to hold public office, your right to serve on a jury, your right to obtain a passport, your right to receive, possess, or transport a firearm, or the ability to obtain employment. Do you understand?
Yes.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that if you went to trial, you have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify to remain silent and not incriminate yourself?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights? And after each right, I'll ask you to respond. The right to trial by jury,
Yes.
the right to remain silent and not incriminate yourself,
Yes.
the right to confront witnesses against you,
Yes.
the right to assistive counsel hired by you or to court-appointed counsel if you cannot afford an attorney at the trial of your case,
Yes.
the right to presumption of innocence,
Yes.
the right to testify on your own behalf and to present other evidence,
Yes.
the right to subpoena witnesses and compel the production of evidence,
Yes.
the right to have the charge against you proved beyond a reasonable doubt,
Yes.
and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
With respect to indictment 22 SC 183572, how do you plead to the charges in that indictment?
I plead guilty.
Is this guilty plea freely and voluntarily given with a full knowledge of charges against you?
Yes, ma'am.
Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes.
Do you understand you have 4 years from today's date to file a habeas corpus petition challenging the voluntariness and constitutionality of this guilty plea?
Yes.
Do you understand that you have 30 days in which to appeal your conviction based on your plea today?
Yes.
And do you understand that you have until the end of this term of court to file a motion seeking to withdraw your guilty plea?
Yes.
Your Honor, if this case were to go to trial, the state would expect, or if we were to continue this trial, the state would expect to show, or evidence has shown and will show, that Mr. Huey conspired with others to participate in YSL through a pattern of racketeering activity, and multiple defendants, as well as unindicted co-conspirators, have committed overt acts to further this conspiracy, to include drug sales, aggravated assault, and murder. Also, it includes posting on social media, asserting the violent nature of and the dominance of Young Slime Life, aka YSL. Specifically, Mr. Huey himself participated in 2 robberies. He posted on social media, and he engaged in text messages with his fellow co-conspirators. On April 26, 2019, Mr. Huey, along with another individual, armed robber Mr. Gawad Maynard, at an apartment complex located on Masargo Drive in the Buckhead neighborhood in Atlanta, Georgia, Fulton County. He robbed Mr. Maynard at gunpoint and pistol whipped him. Mr. Huey was wearing a very distinctive yellow jacket. He stole a ring, a necklace, a luxury wallet, and other items. He then fled the scene in a black Mustang. Portions of this robbery, Your Honor, were caught on surveillance video. After the robbery, Mr. Huey was seen on his social media account with the ring and necklace that were identical to the items that were stolen from Mr. Maynard. Additionally, on IG, on Instagram, or on social media, there were several pictures of Mr. Huey photographed next to a black Mustang. There were several pictures. Lastly, there were pictures of Mr. Huey on his social media wearing the same distinctive yellow jacket that was seen on the surveillance video. Based on that evidence, Your Honor, arrest warrants were issued for Mr. Huey. While on bond for the April 2019 armed robbery, Your Honor, on October 1st, 2020, Mr. Huey went to the apartments located at 250 Fulton Street, Atlanta, Georgia, Fulton County, to meet with Mr. Gary Holloman. Gary Holloman, who is now deceased, told law enforcement officers on the night that he was robbed that Mr. Huey, who he knew, asked to meet with him so that Mr. Holloman could give Mr. Huey money to put on another co-conspirator to Aquarius Mender's books or commentary at Fulton County Jail. Aquarius Mender, who is a co-defendant and co-conspirator, is the nephew of Gary Holloman. Mr. Mender and Mr. Huey were friends or are friends. Mr. Holloman agreed to meet with Mr. Huey at the location. While at the location, Mr. Huey, along with another individual, approached Mr. Holloman. One person had an assault rifle. They took from Mr. Holloman his car and his money. They also robbed another young lady by the name of Alicia Coppage. Mr. Huey and the other unidentified individual fled the scene and left. Mr. Holloman immediately called the police. When police arrived, Mr. Holloman was able to use another cell phone to track his phone. He was able to track that phone going in the direction of I-75 South, and ultimately that phone was located on Oak Drive, which is in the Cleveland Avenue area, which is the area or territory for Young Slime Life. Also, Mr. Holloman was able to show police officers the social media pages of Mr. Huey to identify him. Initially, the police marked this case as an information, and the case was not initially investigated. However, about 1 month later, Mr. Holloman went to the police headquarters, spoke with investigators. He was able to pick Mr. Huey out of the photographic lineup. Subsequently, investigator Marissa Viverito, who was formerly with the Fulton County District Attorney's Office, found a jail call with Aquarius Mender, Mr. Mender's mother, as well as Gary Holloman discussing the robbery, and Mr. Holloman discussing what occurred to him. Arrest warrants were taken out for Mr. Huey. He was initially arrested in November of 2020. During that arrest, and pursuant to a search warrant, his home was searched. In that search, they found two rifle handguns. Also, they found items belonging to an individual by the name of Chandler Durham. During that search warrant, they seized Mr. Huey's phones, and pursuant to a search warrant, did a search of those phones. Upon seeing the items from Chandler Durham, investigator Viverito checked the Atlanta Police Department's database to find if there were any police reports associated with the Chandler Durham. She found a police report from March 12, 2020. In that report, Chandler Durham reported that while he was working at a music studio, his car and additional items to include a luxury bag were stolen. After finding the report, investigator Viverito went through the contents of Mr. Huey's phone, and she saw a few text messages of notes. She saw a text conversation on March 12, 2020 between Jeffrey Williams and Mr. Huey. Jeffrey Williams told Mr. Huey that they needed to take that shit back. Mr. Huey denied involvement in taking the items and blamed it on another person. Mr. Williams then told Mr. Huey in his text message, if he doesn't take it back, he's going to die. Also found in Huey's cell phone were two incidents in which Mr. Huey and Mr. Williams were in conversation with each other regarding rival gang member Rashawn Bennett, aka Wyatt and Lucci. On January 19th, 2020, Mr. Williams sent a flyer to Huey with a performance location of Wyatt and Lucci. The text message read, handle that tonight, flat. Then Huey responded, flat. Your Honor, based on the state's understanding, flat means slime love all the time. Then on September 2nd, 2020, Mr. Huey sent a flyer to Mr. Williams with another performance location of Mr. Rashawn Bennett. Mr. Williams texted, "Flatty candle and stay very low." Huey's response was slack and for sure, I've been out the way. And appreciate you for everything, my brother. Never about money with me. I'm built on loyalty. Williams' response was slack, handle that, I got you. In 2021, we were able to recover another phone from Mr. Huey after he was subsequently arrested on grand jury warrants. When we did a search warrant of that phone, there was additional communication between Mr. Williams and Mr. Huey. Mr. Huey told Mr. Williams on November 14, 2021, "You know I'm ready to handle the business and you'll sit down if I got to about any one of y'all on my mom." This text message followed information that was provided to investigator Riverito by Kenneth Copeland. Kenneth Copeland, during an October 2021 interview, advised investigator Riverito that he was aware of a potential plot to harm another rival gang member, Kelvin Watts, also known as Shell Kel, at a venue, Diamonds of Atlanta on Northside Drive. Mr. Coleman advised that he was aware that Huey was to participate in this plot to harm Watts, and he attempted to tell Huey not to participate. Lastly, Your Honor, on February 18, 2022, while housed at the Fulton County Jail, along with Aquarius Mender, they were both housed in the same cell. There was a search of that dorm specifically, and inside of the cell, there was a shank and an illegal cell phone inside of their cell that they shared. And based on what we know from other evidence that we had, that cell phone was used to communicate with other YSL members. Your Honor, this is the evidence that we believe would have come out had we continued the trial. Given where we are, Your Honor, and the charges, we made a decision to resolve this case with Mr. Huey for the offer that was relayed earlier, Your Honor. And I have a copy.
All right, and with regard to the offer, I just wanted to be clear that on counts 6 and 19, which are possession of a firearm during the commission of a crime, while this 5-page plea agreement document reflects that those are going to be served on probation, the intention of both parties is that those 2 counts be suspended.
Yes.
Is that right?
Yes, Your Honor.
Okay,
Yes, Your
and in your global sentence, it says 5 years suspended, and so I assume that that's what y'all meant by that.
Yes, Your Honor.
Okay. All right. Mr. Matthews?
Yes, Your Honor. Good afternoon to this honorable court, Your Honor. I'd like to begin by expressing to the court that we emphatically and categorically deny all of the recitation that's been presented by the court with respect to some of these allegations that's been laid out by the state. However, we do recognize that there are enough factual allegations in the recitation to support each and every count to which Mr. Huey is pleading this afternoon. So we do stipulate that there is enough to move forward with this plea. For those reasons, Your Honor, we are standing before this court to talk to this court about the acceptance of responsibility with respect to Mr. Marquavius Huey. Your Honor, Mr. Marquavius Huey was born in Atlanta, Georgia. He lived in the Jonesboro South community, a neighborhood project in the Atlanta community. He grew up there. He's seen a lot of things in his short 28-year life. His father was murdered in 2010, and he's been without a father for a number of years. He's been raised by his mother as a single parent. He has a number of siblings. There have been times when Mr. Huey and his mother and his family have been homeless and have lived out of a car. So he's had a very, very hard life as it relates to his upbringing. Notwithstanding that, Your Honor, He did manage to graduate from high school. Mr. Huey, Your Honor, now has 2 children. He's 28 years old. He has 2 children. He has a 5-year-old son, Your Honor. He has a 2-year-old little daughter that was born in July of 2022. He has never met or seen his daughter in person until today, as she's here in this courtroom. He recognizes that choices puts him before this court in this case. Your Honor, we are asking this court to take into consideration that he has no prior felony convictions. I've had a very long time to get to know Mr. Huey because I've been with Mr. Huey on a regular daily basis during the week since January of 2023. I've got a chance to know him. I've got a chance to work with him on his case regularly. And he wants to, when he gets out of custody, Your Honor, he wants to do a number of things, 2 in particular. He wants to start and become affiliated with a nonprofit organization where he can be able to talk to young children, teenagers, because he was a teenager when he lost his father, and things begin to take a turn for Mr. Huey. He wants to be able to tell teenagers, young boys, young Black boys, he wants to be able to say to them, don't do what I did, and you have another way in which you can go. And he wants to be able to share his experiences in that way. I have linked Mr. Huey up with an organization called the Young Generation Movement. And I've known that nonprofit organization and the founder of that organization for a long period of time. He's also present in this courtroom. And I've linked Mr. Huey up with them so that when Mr. Huey gets out of custody, he will be able to have an organization that can mentor him, that he can align himself with, where he can begin to engage himself with anti-violence nonprofit conduct and mentoring other young people. He also, in terms of being able to earn an income, because he is now, Your Honor, if this court accepts this plea, Mr. Huey will now, for the first time, be a convicted felon. He is not first offender eligible. He wants to get his commercial driver's license, Your Honor, and he wants to get a trucking company and be able to earn a living for himself, because he recognizes that it's going to be a challenge for him to be able to go out and apply for jobs and be able to get income by getting an employer to hire him. So he's going to focus and target himself to be able to fend for himself so that he can take care of his young children that he has helped to bring into this world. Your Honor, we are here before this court because it's an acceptance of responsibility. We recognize that this has been a very long, enduring trial, and we have come to a point where we have painstakingly negotiated with the state of Georgia, and we've come up with a negotiated resolution that we believe is one that is fair. We believe that is sufficient to recognize the seriousness of the charges that are before the court. And we believe it's one that will cause Mr. Huey to be able to see the light of day in a reasonable period of time. Mr. Huey has been in custody. I'd like to enter into the record, Your Honor, as Defendant's Exhibit 1 for sentencing purposes, a proof of incarceration from the Fulton County Sheriff's Office. Mr. Huey, through the computations of the various times when he was arrested on these charges and released, and from the time that he's currently been in custody to the present, He has approximately 4 years under his belt against that 9-year sentence, and that 9-year sentence is parolable. So we're going to enter that as an exhibit before the court.
All right, that'll be Defendant's Exhibit 1 to this plea hearing. And as you know, and as I'm sure you have shared with Mr. Huey, it's ultimately the Department of Corrections that calculates the time served portion of the sentence. So it'll ultimately be up to them, but I will include that as a part of my sentencing sheet as well.
Thank you, Your Honor. Thank you. It's been an absolute pleasure and honor to represent Mr. Marquavius Huey, along with my son, Attorney Carlton Matthews Jr., who also would like to address the court at this time, Your Honor. So we're asking this court to accept the negotiation that has been represented to the court and Mr. C.J. Matthews.
Yes, good afternoon to this honorable
Good
court.
afternoon, Mr. Matthews.
I've been gracious with this opportunity to represent and serve Mr. Huey. Mr. Huey is an honorable young man. Mr. Huey does not allow his mistakes to define him, but he is remorseful, Your Honor. He has learned, grown, and became a better man during this trial. Mr. Huey will have a release date, Your Honor. I'm confident in him that he will be a working class citizen in society when he is released. We thank this honorable court and respectfully ask this court to accept this plea on today.
All right, thank you, Mr. Matthews. Mr. Huey, I am sure that Mr. Matthews Sr. and Mr. Matthews Jr. have, I know that they have been working with you and negotiating with the state for over, I'm sure, the entire course of this trial and proceeding, but very, very hard over the last week and a couple of days to get where we are right now. And I know that you know that given the severity and the number of charges that you were facing, that had you been convicted of all of those charges at trial, you were looking at the possibility of 3 consecutive life sentences, plus I think about 100 years after that. So the fact that the state is recommending jointly with your attorneys that your total sentence be 25 years with 9 of those to serve is, it's frankly remarkable. And something that you should not take for granted or take lightly at all. These are very serious charges. And I hear what both Mr. Matthews have said about the challenges facing you in your life, and I am sorry for the loss of your father. One would hope that to have anybody that they love taken from them in a violent way like murder might have an impact upon their lives that would lead them in the right direction, but it's not particularly surprising that sometimes that's not what happens and it goes in a worse direction instead. I hope that with your age and with having really been faced with the distinct possibility of spending the entirety of the rest of your life in prison, the fact that you are getting this opportunity is not going to be wasted. I hope that you appreciate what the Matthews have done to go out of their way to line up somebody to be looking out for you when you are released from prison. And I want to ask you, just like I have asked both Mr. Nichols and Mr. Ryan, is this your decision to enter this guilty plea? Because no matter what your attorney's advice is, it's ultimately up to you whether to plead guilty or continue with the trial. So is this what you want to do?
Yes, ma'am.
All right. And have you had enough time to consider all of the different scenarios and to discuss everything you wanted to with your attorneys?
Yes, ma'am.
All right. All right. I think it's very clear that this plea is to your benefit, considering the potential downside of moving forward with the continued trial. I find there to be a factual basis to this plea. I appreciate the fact that y'all have stipulated that there is a factual basis. And I find the plea to be freely, knowingly, intelligently, and voluntarily entered with an understanding of the consequences, and I will accept it as such. And I will sentence in accord with the negotiated recommendation. I'm not going to read everything out again. We thankfully got it in writing for the sentence sheet, but in accord with what was put on the record and what is reflected in this, this document. With a total sentence of 25 years to serve 9 in custody, balance of 14 years after that, 9 of those on probation and 5 suspended. And I'm going to impose the special conditions that you have already acknowledged and acknowledged that you would abide by. And, you know, somebody with a high school diploma, which is more than a whole lot of people ever achieve. So you've already achieved and proven that you can achieve good things, and who is only 28 years old, and who can really look down and already see the light of day for a release date. You need to make sure that during your time incarcerated that you don't pull any other kind of thing that you have been, you know, that you actually are pleading guilty to at least some of by having contraband or in any other way getting in trouble, because that's not going to bode well. I am going to recommend a transition program for you. I know that there's a lot of different job training available in our correction system, so I hope that you take advantage of that. And you know, whether it's a commercial driver's license or whether you find something else that you want to do while you're in there, be making good use of your time while you're in there and furthering yourself. And you have had a fine example next to you for the past 2 years of what somebody can do with their lives. So don't forget about that, and be the father that you need to be and that you ought to be to your very young children. They're still going to be very young when you get out. And please make sure that you abide by all your probationary conditions, because if you don't, then you're going to be back to see me. And because I recognize how much of a break you're getting right now, I'm probably not going to be as lenient if you come back before me again, because you are getting a huge opportunity to turn your life around. Okay.
Yes, ma'am.
All right, so that's the sentence of the court, and I want to wish you good luck and good fortune. You can get through the next few years, and then you can have the rest of your life to do good work with.
Can you address the court?
Yes. I should have asked that. I'm sorry.
That's okay, Judge. Thank you.
I want to thank the court, thank God. And I want to apologize to my kids, my family, and everybody who done supported me in this stressful process. I plan to do my time, come back, be a better man.
I'm glad to hear that. Thank you.
Your Honor. Thank you.
All right. All right, let's take a recess.
Ladies and gentlemen, the best has yet to come. Stand by. There's more to come, ladies and gentlemen. There's more to come. As I tweeted earlier, there are several pleas coming. Stand by. I mean, ladies and gentlemen, there's a lot to unpack what's happening. There are now only 3 defendants in the courtroom. There are only 3 defendants in the courtroom. 2 have taken pleas today, and 1 has taken a plea yesterday. This is a significant turn of events, but there's more to come, ladies and gentlemen. There's more to come. Just do me one favor, please. Put a 1 in the chat if you can hear the sound of my voice. Put a 1 in the chat. Those who are watching on Twitter, those who are watching on YouTube. Make sure you are supporting this platform. It's going down. It is going down, ladies and gentlemen. That's right. Don't be shy. Don't be shy. You can tip your reporter. You are free to tip your reporter. Shout out to a real paralegal. Make sure if you don't have a membership, get one now, because we go into membership mode only for my next exclusive. Membership mode only. Make sure you are one of those who have a membership, ladies and gentlemen. How many days in a week? There's 7 days and 7 nights. I hope you guys are ready for what's about to happen. I hope you're ready. Hold on a second. Hold on, ladies and gentlemen, stand by. Hey, they watching me. They're watching me. Oh my goodness. Several, ladies and gentlemen. Several. No, she is not. Stand by. All right, ladies and gentlemen, you still with me? Are you still with me? Can you hear me? Can you hear me? Mic check. Looks like we have to come back. We have to come back, ladies and gentlemen. Never ending, never ending. I will be going inside the media room. Stand by. Okay, ladies and gentlemen. So we have to be back here tomorrow. Tomorrow. I will be going live in the membership section tonight at 9 p.m. 9 p.m. I will be going live in the membership section at 9 p.m. That's at Mr. Dennis Byron on YouTube. I will be going live at 9 p.m. I'm heading home right now. Thank you guys for tuning in, and we will give you the updates from not just today, but what my sources have told me, and we'll see how this thing plays out. I really do appreciate all you who came in to watch the live, and I want to make sure you know that we good over here. We are good. So it's a few things we have to update tonight. So you guys, make sure you are on the in the membership section tonight at 9 p.m. Be there. You know how that thing go. You know how it go. Be there or be square. Okay. Someone had a question before I left. Oh my goodness. Donna Hallman, how can you be a member? Look at the scrolling bar there. Look at the scrolling bar. I got mods in here. They ask a question, mods. You got to answer them. Come on, mods. Don't drop the ball. 9 p.m. tonight. Members only. 9 p.m. tonight. Members only. It is going down, ladies and gentlemen. 9 p.m. tonight. Make sure you are locked in at 9 p.m. We are going live at 9 p.m. Members only. Make sure you are in the building. Everything is there, I believe. I think my cash app and wait, hold on a second, guys. Hold on. Stand by. Somebody just brought something to my attention. Stand by. Hold on. I tell you what. We're gonna leave the stream up, and then we're gonna switch to membership only. The stream will stay up. We'll have the membership link posted here as well. But it's going down 9 p.m. tonight. Okay, real quick. Thank you to a real paralegal for the super sticker. Thank you, Harper Blue. What it do? A new member. Welcome. D, I see you. I see you, D. Always there. Oh, Southside. Super stick. Appreciate you, Southside. Donna Hallman. Good evening. Good evening. Troyell, welcome to the new membership section. Hope you're a member. Where you a member at? You on Hip Hop Inquirer or you're on Mr. Dennis Byron? I don't know where you're a member at. We got several channels going at this time. But I'm gonna leave that bar up there where you guys can see how to join the membership section tonight at 9 p.m. Do not be late, because we like to start on time for our members. Don't be late. We'll post an update here, so the stream will stay up. So stand by.